Well, hello, we're back. So good to see everyone. You look marvelous. You lovely people. Missed y'all. Been busy with work and putting together a great lineup of shows to come. It's going to be real exciting, y'all. Been working really hard on it. Tonight, I got a real special treat. It's a friend of mine. He's been an attorney for 16 years now. Very, 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 very versed. He's never worked a DP case, but he's worked many criminal cases. He's worked both ends. And he's going to answer a lot of questions tonight. So, and that's what I want from all of you, is I want you to learn. You know, something was just brought to my attention. I don't mean to get off topic, but something was just brought to, but this other creator just actually put a survey out. You're not going to believe this, people. This person swore he would never do this again, and he'd never go down these, never jump down these rabbit holes and blah. I'm not even going to say his name. It's not worth. He's just a little weasel. But he actually put out a survey to his subs. How many of you think Dylan had something to do with this? And do you know what the end result was? This just shows you the different demographic that we deal with here. The different types of people from his group to this group of people. 79% of the people he polled believe that Dylan was involved with Bryan now. Now Bryan was involved, but he had help from Dylan. So we're going to jump down that rabbit hole. These people are unbelievable. So what we're going to do is my buddy Matt Rowland is going to educate each and every one of you. We're going to go to school tonight. Now, Matt and I have the same theories and beliefs. We disagree on some things, little minor things. But I'm a cop. He's an attorney. That hearing that happened last week was pretty telling. For 30-something minutes. Got a lot accomplished in that hearing. Denied, by the way. But now we're talking about potentially pushing this thing back to summer of 25. Why? Oh, we got 51 terabytes. Oh, that's why. Couldn't be that those 51 terabytes are full of 3D video, photos of the crime scene, all this other video from other places. You know, couldn't be that old Ann Taylor's just kind of blowing it out of proportion a little bit so you all can hear it and you can take that 51 terabytes and say, oh my goodness, there's no way on God's green earth that they're going to be able to go through that 51 terabytes and have it ready by this summer, by June, when the prosecution's like, let's go to trial. We're ready. Oh, well, what about discovery? I would submit they probably, now I'm just guessing, they probably have 90% of discovery. They're still waiting on a little bit of stuff to come in from all these other agencies and entities that have done work on this case. But they'll be ready by June. But old Ann Taylor, she won't. She won't be ready. She wants to push it forward. And then her old partner in crime there had the audacity to actually make a comment, and you'll hear it if you haven't heard it already, that the state just wants to kill this guy, which I took serious offense to. I thought that was probably one of the most unprofessional comments I've ever heard an attorney make. I kid you not. That was unbelievable. So I would hope that Judge admonishes the hell out of that attorney for doing that. He didn't want to do it live on the interweb, but I guarantee you, probably handed him his butt for that one. But he got it out there, didn't he? Got it out there for all of us to hear, just like old Ann Taylor plays on words. Constantly pulls those heartstrings and plays on words and tries to throw that doubt out there. Now, as suspected, they want to change venue. I mean, Idaho is not a densely populated state, people. It's really not going to do them any good to change venue. But we're going to talk about all that stuff. Matt's going to go over a lot of this stuff. I'm going to sit back and I'm going to have dialogue with him. But I want Rachel and Stacy, I want you guys to try and field some of these questions that come in tonight. Please hit that like and subscribe, y'all. If you're in here, I got over 100 in here right now, just like that. If you could go down to where that little thumbs up is and click that thumbs up at least and subscribe if you can. Doesn't cost you anything. You'll never get contacted unless you ask to be contacted. But it helps with the algorithm. And we're reporting responsibly here. We don't make up crap here. We don't run down rabbit holes. We don't ride the coattails of dead people. We don't do that here. We don't make crap up. We don't do it. And we're never going to do it. We're going to provide you with solid intellectual opinions. You're going to have Matthew tonight is going to answer some questions, and he's way more qualified to answer some of those questions than I am. From the investigation standpoint, I'm qualified, but I know what I know because I've dealt with it. He knows what he knows because he handles the paperwork. He handles the clients, the defendants, the state, whatever side he's on at the time, the firm that he represents. Very, 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 very versed, very well-rounded. And I'm proud to have him as my friend. And on the show, he's helped me out with a civil case already. Got me some cash like that. So we'll see what happens with some future cases. Just decided I'm going to move forward on another one because that person thinks that they got away with saying stuff because I think that it was correct. But I just let them run their mouths. Just let them hang themselves, and I'll be getting paid. Remember, you hear me say it all the time, just because you can say it doesn't mean you should say it. And when your actions have consequence, the First Amendment does not protect you. Fact. So what I'm going to do is I'm going to play this hearing, and I'm going to bring Matt on. Hold on one second here. All right, Matt, are you in here?
I'm here. Good evening, John.
Good evening, ladies and gentlemen. I'm going to introduce attorney Matthew Rowland. And I'm not going to have Matt talk about his firm or any of that stuff. That's none of your business, to be honest with you. And Him coming on this show has nothing to do with his firm. He's coming on this show as a favor to me. And he's going to open himself up to questions. And we'll go from there. But right now, we're going to play this. And then, Matt, I want you to feel free to just chime in when you want to handle something, or I'll chime in and I'll pause it. And we'll go from there. How's that sound?
That sounds great.
All right. So we're going to start it up now. Rachel and Stacy, I'm going to send you the link because I need you guys to come in. So what I want you guys out there to do is what Rachel and Stacy are going to be doing, and my other mods will be modding, but those two will be focusing on questions. And when a good question comes in, they're going to kind of pick an opportunity in a little lull in our dialogue, and they're going to say, hey, John, so-and-so's got a question for Matt or yourself. And we'll try to answer as many questions as we can, but we're not going to get too off task here. I want to cover this. So try to hold your questions until afterwards, after we're done with this. So, and we'll go from there. All right, here we go, Matt. You ready? Matt, you there? You're muted.
Ready.
All right, here we go.
Remote. Mr. Koberger obviously is in his courtroom. The state is represented by Mr. Thompson, Ms. Jennings, who is here also remotely, Mr. Nye, and Ms. Beatty. So we're here. This is an open case. You probably know we had a closed hearing this morning, and that was necessary because that was related to the grand jury, which is secret. So that's what that was all about. I'm assuming that you've all seen the amended order governing courthouse in.
Hey, Matt.
Yes, sir.
So that part right there, I just want to address that real quick. When he's talking about the grand jury and it being secret. So do you want to tell everybody what he's referring to right there?
Yeah, absolutely. So states have grand jury processes, and a grand jury is a prosecutor's tool primarily. This is a tool that is available to the state where the state can convene a grand jury. The grand jury is impaneled, and the state can present evidence to the grand jury and attempt to get an indictment or a true bill, it's also called. And the state, the benefit of a grand jury to the state is that it can essentially present the evidence that it wants. It can be a little bit selective. And
hey, hold on a second, Matt. You're either getting too far away from the mic or not close enough. I don't know, but you're kind of going in and out just a little bit. Can you get a little closer?
Sure. Is that any better?
That's better. There you go.
Okay. So the grand jury process is available to the DA, to the state, and it's a secret procedure. A grand jury is impaneled, and the state can present essentially the evidence that it wants to present to the grand jury. It can be selective and sort of present its best case, if you will, to the grand jury. It can call witnesses and present evidence. And so the result of a grand jury procedure is that you're either going to have an indictment, which is also called a true bill, and that's the kicking off at the beginning of a criminal case. And in this case, it was a little unique because you had a preliminary hearing, but then at some point the state decided to impanel the grand jury, and the grand jury returned a true bill in this case. And so one of the issues that led to this hearing last week was the defense filed 2 motions to dismiss the grand jury indictment, and they cited 4 grounds essentially, and so that's why we had the hearing, at least in part why we had the hearing this past week.
Right. Okay. I just wanted to clear that up because that's often a question. People don't understand that grand juries are secretive for a reason. And you just laid it out perfectly. I've said the same thing, but hey, coming from you, it holds more weight. You know what I mean? All right. So I'm going to start it back up here.
Courtroom conduct. We made some changes, and you probably also know that we are streaming now, and that is on a YouTube channel. If you don't know that, you can go to the Supreme Court, I guess, website, and you can get that channel if you don't have that already. So you don't want to be on a camera, you probably should leave. But generally, we can't see very well farther back in the courtroom. So just so you're aware of that. So today, we are addressing reconsideration of the order denying motion to dismiss the indictment, and that order is focused on the claim of inaccurate instructions to grand jury. Also coupled on that is the potential for permission for appeal for interlocutory order. So, and a stay of proceeding in the case.
Hey, Matt, I'm mute. Matt.
Yes.
So cover that with them interlocutory, that portion of it real quick, because I know that's been a question.
I'm happy to. Right. So the rules of criminal procedure in Idaho provide for an interlocutory appeal process. And for those interested, it's Rule 12 of the Idaho Rules of Criminal Procedure. And Section A of that rule, it sort of defines what interlocutory order is. And it's an order from the court, or really an administrative agency too, that involves a question of law, and there has to be a substantial ground for difference of opinion about the legal issue, and if there's an immediate appeal, it might materially advance the resolution of the litigation. And so, what's the controlling question of law that they're talking about in this case? Well, it's the standard at grand jury level. So, is it probable cause or beyond a reasonable doubt? And what we're going to see is that they couldn't get over the substantial grounds for difference of opinion question first, because all of the case law and the statutes say that the standard is probable cause at the grand jury level. And even the defense brief conceded that essentially the law doesn't support our argument here, but they made the argument anyway. And so you have to ask, if the reason it's permissive is that the defense has to ask judge for permission for interlocutory appeal, which we're going to see that he denies that permission.
Right. So the burden of proof Has nothing to do with this. It's a PC. What a lot of people don't understand is there's a huge difference between a grand jury and a criminal jury. So the grand jury only has to establish probable cause to move forward with the proceeding. So for everyone out there that thinks that the grand jury has to be unanimous and things like that, we've gone over this before, but it does not. So what was the standard out there? Do you know what the standard is out there? Is it what percentage of the grand jury has to move forward? I mean, I think they had 6 that held out, but that wasn't enough. I know every state's different, but you know, some grand juries are 24 people. You know, so but you know, we're one of only, I think, am I right in that we're one of only 2 countries that still use a grand jury? I think, if I remember right. But anyway,
It's it really is a tool that states like to use and district attorneys like to use, and I mean especially in a capital case, the defense is not involved in the grand jury process. It's purely a tool that the state can use, and and some people, I've heard people say, well, it's not a fair process because the defense is not involved. Nevertheless, it's something that multiple states still use, and for whatever reason, we don't know, the state elected to use a grand jury in this case. But the standard, whether they had gone to a preliminary hearing or whether they had decided to run it through a grand jury, is probable cause.
right.
In the history of Idaho law, dictated that the standard is probable cause, and so that's what happened in this case. And as we'll see, the judge reaffirms his prior order denying their motion to dismiss. It was a decision that was made quite a while ago, as he says, near the end of the hearing. And judges don't like to look back in time and revisit their rulings. They really don't. They don't like to be told that they're wrong. So,
hey, real quick, Matt, are you on a mic or are you on a phone? What are you using a mic?
Mic.
For some reason, it's like we can hear you the whole time, but it's like you're fading in and out. So I don't know what the deal is with that, but it's just like you're perfectly normal, and then you're like, no, and then you come back. We can hear you, but it's just kind of weird. I don't know if there's an adjustment that you can do. But I believe that they went with a grand jury. Of course, the main reason is to move it right along and not to have these unnecessary hearings. Am I correct?
Well, that could be. I think another reason is if you have a witness you may not want to necessarily subject to cross-examination at that point in time, you might convene a grand jury and have that witness testify at the grand jury. Or if you want to protect an informant, potentially, you would want to conduct you'd want to run the case through a grand jury to see if you get an indictment. But I think that expediency in moving the case along is probably part of it. Sometimes I think too, the state has about their case at any level. You might want to convene and impanel a grand jury. So 3 or 4 reasons why you might want to do it.
Right. All right, I'm going to start it back up. Hold on a second. Here we go.
I think that's all the preliminary. Is Ms. Taylor.
Mr. Logston will be arguing, Your Honor.
Okay, Mr. Logston.
Thank you, Your Honor. I'm gonna, I guess, be succinct since we argued almost the very same thing this morning. But in essence, what we're asking the court to do is to give us the court's blessing to take up the issue to the Idaho Supreme Court. I think the court has noted that it's certainly an interesting issue. The Idaho Supreme Court does have a rule that essentially lays out that this is to be done in very rare circumstances, important issues where people may disagree and that may make it more orderly in a particular case. Our argument is that for this case to exist, the indictment needs to be valid. If there's something wrong with the indictment, that's something that certainly should be addressed. We're also concerned about the fact that there is case law that says that if this case goes to trial, issues with the indictment may become essentially mooted by that and would never be answered. And there's relatively little in the way of case law in Idaho in the last 20, 30, 40 years. And so without permission to appeal, we may never get an answer on this. And certainly that's very important to Mr. Koberger, because whether or not there's a valid indictment in this case is going to decide whether or not he sits here and whether or not a trial should occur, et cetera. One of the major issues is whether or not that's going to have an issue with the timeliness of this case. And my understanding is that's going to be the next argument that comes after this one. And so we believe if a trial is set out as far as we think it ought to be, that an appeal at this point won't disturb where we think a trial should occur in any case. And in any matter, this isn't our attempt to achieve some delay. This is our attempt to make sure that our client is getting due process at every step in this case, and that nothing is being left, no stone left unturned. Thank you, Judge.
Thank you, Mr. Logston. Mr. Nye.
Thank you, Your Honor. I want to start with the rule that was just referenced. It's Idaho Appellate Rule 12, and it governs interlocutory appeals. And the criteria in that rule set out two factors the court is supposed to consider. The first is whether or not there are substantial grounds for difference of opinion. And on this particular issue, as the court stated in its order, the standard of proof for grand juries in Idaho has been consistently probable cause for at least 3 decades. That doesn't sound like substantial grounds for a difference of opinion. And in fact, the defense conceded in their opening brief on this issue that, quote, the whole of modern jurisprudence on this issue is against this novel theory that they've raised. So they haven't met that first factor. The second one asks whether an immediate appeal may materially advance the orderly resolution of the litigation. And I have not yet seen in their briefing or heard in their argument any path forward for them in which winning this appeal materially advances this litigation. I think if we're all being honest with ourselves, a trial in this case is going to happen. And the question is when. And if we send this case up on appeal, even if the defendant wins, the law clearly allows for us to bring the case back. Even if the Idaho Supreme Court goes out on a limb and says, you're right, the standard of proof in a grand jury should be beyond a reasonable doubt, we could use a normal complaint and probable cause hearing in front of a judge. So it would be the same standard yet again, and we would go in a whole circle, basically resetting the case to be where we're at today. We need to get to a trial in this case. And that brings me to my final point. I'll also try and keep this short. There are secondary factors that the Idaho Supreme Court has looked to in addition to that rule, even when those first 2 factors are met, to decide, is this actually the case that we want to take an interlocutory appeal? And my read of those secondary factors is it's really asking, like, what is the effect of this appeal on the litigation and on the parties and those involved? And I would just like to point out to the courts, under the rules, this is Idaho Appellate Rule 13F, and it's talking about the stay upon permissive appeal. And it says in F sub 2 that the granting of a motion for permission to appeal under Rule 12 by the Supreme Court automatically stays the entire action or proceeding until the appeal is terminated. So at that point, there's no more discretion. It automatically this case hits the pause button. But more than that, Your Honor, it continues and says, and during that time, the district court or administrative agency shall have no power or authority over the action or proceeding. We're not just talking about a stay in the proceedings. We are talking about this court losing its power and authority over this case while the appeal makes its way through the appellate process. That is going to cause significant delay. As we're about to have an argument or a conversation at least about scheduling. And there is a lot that needs to be done before this trial happens. And this court will have no power to address those issues if this case is pending on appeal. Now, in full disclosure, there are some exceptions to that rule, but it's the exact same exceptions that apply to an appeal as a right after judgment. So it's things like you can change the sentence, you can sentence the defendant, you can change bail, things like that. But for discovery, we've had the genetic genealogy issue that's still out there. We're working and making progress on, but pause button on that, pause button on discovery, pause button on change of venue, pause button on motions about experts and who can say what. It would significantly delay this litigation, which brings me to my final point, and that is I don't want to lose sight of the fact of the seriousness of this case. We are talking about a quadruple homicide. Under Idaho's law, not only are those who were killed victims, but every single one of their immediate family members is a victim. And in this state, in Idaho, our victims have a constitutional right to a timely resolution of the litigation. We are already quite a ways out. And the idea that we would hit the pause button and take power away from this court because there is a interesting issue for the Idaho Supreme Court to address is not something that this court or any court should tolerate.
Okay, Matt. Now's the time to shine again. So I find that comment very interesting, very matter of fact. And he nailed it. He hit it out of the park right there. Now, what kind of impact is that going to have on Judge's decision? I don't know. I hope it does. But what are your thoughts?
Well, I think you did a very good job of doing what a probably experienced trial prosecutor would do, which is stand up, cite the rule, first of all, say what the rule is, and apply the rule to the facts of this case. And as he stated, there's really no significant difference of opinion amongst courts about what the standard is when presenting a case to a grand jury. It's probable cause. And as he stated, that standard has been reaffirmed by the courts over the past 30 years. So they can't get over the first hurdle that there's a significant difference of opinion on a substantial controlling question of law. In terms of how it affects the litigation, well, as he pointed out, I mean, even if the court agreed with you essentially would have to start over and you'd be right back in the court for a probable cause determination at a preliminary hearing. And I think he said at some point that, we all, if we're being honest with ourselves, we know the case is going to trial. So I think these things are a consideration for the judge as well. But you have to have both aspects for permissive interlocutory appeal. And if there's no substantial difference in the controlling question of law, they're going to get permissive interlocutory appeal.
Right. I think he did an excellent job right there. It was very, very, very telling, and really made the defense look bad, in my opinion. I'm just saying.
Hey, John.
Yeah.
Quisley Bears is asking if Matt, if the Idaho standard for a grand jury is probable cause for beyond reasonable doubt.
Did you hear that, Matt?
Probable cause.
Yeah,
Let's see.
it's
I'm gonna put it. I'm gonna put
saying,
it up here. It says,
yeah.
"Ask Matt if Idaho's standard for a grand jury is probable cause or beyond reasonable doubt." It's probable cause. Beyond reasonable doubt is a trial jury. Correct, Matt?
That's correct.
So a grand jury, Quisley Beers, is totally is not remotely the same. The requirements of a grand jury are just to establish the probable cause to move forward with the trial. It's nothing like a criminal proceeding. It doesn't have to be unanimous. And this is wherein lies there's a lot of confusion. They think that just because the whole grand jury did not agree that that's grounds for, their decision to be overturned. That's not the way grand juries work. Many cases that have gone to grand juries were not unanimous. In fact, I would submit probably most were not unanimous. Wouldn't you, Matt? Unanimous. In fact. So hopefully that answered your question.
Yeah, I mean, there is confusion about the grand jury process and the difference between a grand jury and a trial jury, because, as you said, the standards are different. Once you get to trial, the state has to prove its case beyond a reasonable doubt, and that is not the case in a grand jury proceeding. They just have to show that there's probable cause to believe that a crime was committed and that this particular defendant probably committed the crime. If you take a case to a preliminary hearing before a magistrate or a district court judge, same standard. And then when you meet the probable cause standard at a preliminary hearing, the judge binds the case over for trial, meaning that there is probable cause, and we're going to send this to trial. So there are huge differences. There are evidentiary rule differences. I mean, when the defense can't participate in the grand jury process, that's obviously a big difference between
Right.
trial and grand jury proceeding.
Right. Thank you.
Hey, John.
Yep.
Black Austin has a seriously important question for Matt. He would like to know if he thinks that Black Austin has a reasonable opportunity with the beautiful white women in the chat this evening.
Matt, you don't have to answer that.
Okay.
All right. That was funny.
I think I have one more too from 80s Kid. I just saw it.
Let me see.
He wants to know if presenting evidence, if they don't meet, can they keep presenting evidence if they don't meet the requirements?
You see it on screen there, Matt? Can they keep presenting evidence if they don't meet the requirements? I'm kind of, you mean in the grand jury? I'm confused. Are you following that question, Matt?
No, I don't follow.
80s Kid, I'm not sure what you mean there. Can they keep presenting evidence if they don't meet the requirements?
They can collect evidence up to the bitter end. Is that what you mean, 80s Kid?
I think he's referring to the grand jury. So if the grand jury, let me see. If the grand jury, if you have the grand jury, part of them want to see more evidence and part of them they don't care, but majority doesn't care. So there is no need to present any more evidence because they're going to move forward with the indictment. I think that's what he's asking. So they could, but if there's no need to, then they won't.
Right. Well, because of the difference in the rules of evidence,
Right.
you don't have the defense. Well, let's say you have hearsay, for instance. You're not going to have a hearsay objection. You're not going to have a relevancy objection. And that's why it's such an advantageous tool for a prosecutor, because that same evidence may ultimately not be admissible at trial.
Exactly. It's almost like a civil case, isn't it? A grand jury. It's almost like a civil case, because in a civil case, a lot more evidence can be heard, but in a normal case, that same evidence wouldn't be heard.
Yeah,
it wouldn't be admissible.
And in civil cases, you also have different standards of proof. You have preponderance of the evidence, for instance, and so the standards are different between a civil and a criminal case. And some of my attorney friends joke sometimes that with some judges, any evidence is admissible regardless of what it is. So,
right. I hope that answered your question, the 80s kid. All right, here we go. We're moving right along.
It's time for a trial, Your Honor. Thank you.
Thank you, Mr. Nye. Mr. Logston? Reply.
Judge, once again, we believe this to be an important issue and one that is worth getting a glance, at least from a higher court, rather than being tucked away and forgotten in the maelstrom that is to come. As the state undoubtedly knows, trial won't put an end to this case. This case will go on for 28 years if they do actually achieve a conviction. So the idea that somehow we're running towards something and that's going to do anybody any good from their standpoint is, I think, false. What we're trying to do is make sure that the things that occur in this case are done correctly. And if you want to talk about how long things are going to take, get some stuff wrong and then see how long it all takes. We're asking that the court would give us permission to go and see if the Idaho Supreme Court would be willing to weigh in on this particular subject. Whether or not the case makes its way to trial at some point is, in our mind, just part of what the court has to look at, particularly in a case where the state's decided that it wants to try to kill someone. Thank you.
Whoa. I had a serious problem with that, brother. That was probably one of the most unprofessional things I've ever heard an attorney say as well. That is not what the state is going to do. And the state actually responds to this. Mr. Thompson, he's not happy with that comment. And Matt, the whole 28-year thing, am I missing something, or is there something that certainly, it wouldn't surprise me if he gets the DP and it goes 28 years before he's finally put to death. But 28 years, what do you think you think he's just being sarcastic there, or what is his deal there? Because I was floored by that comment.
At first I thought maybe, there's some irony because Bryan is 28 years old, but
yeah,
I really, unless he just was, making up a number because of post-conviction motions and all appeals to be exhausted. Other than that, I really don't know.
Yeah, that kind of floored me.
Hey, John.
Yeah.
Kathy Jean would like to ask Matt if Bryan can participate in analyzing his 51 terabytes of data from his cell without the ability to alter, or obviously not the crime scene pits, but like photos, data, and paperwork. He can't get that by himself, can he?
Hold on, I'm gonna put it up there right now. Bryan, can you see that, Matt? Can Bryan participate in analyzing the 51 terabytes from his cell without the ability to alter? Obviously not crime scene pics, I don't think so, but that's not that's something Matt would know. So basically, does he have if he's got a laptop provided to him, can he go through his the evidence in his cell? Is basically what she's asking. If he can, if they can disseminate the 51 terabytes to him and let him review it without the presence of his attorney.
Yeah, it's a good question, and I think it might largely depend on the the administrative regulations of the jail. I mean, certainly, he can meet with his defense team, and I would think
Right.
the defense team could show him documents, evidence related to the case, but could they give him a thumb drive, with electronic material on it? I very much doubt that.
It's certainly possible today, though, because these inmates are getting tablets.
Right.
They can buy tablets. I don't know if people realize that now, but they're able to actually communicate from their cells, which I find highly sus.
Right.
The reason why I know that is because somebody that I know violated it was a female that I know. Her husband violated his injunction because he got a hold of a tablet in jail and he's contacting her. I couldn't believe it. He's got a no
I have
contact
another
order
question for Matt
and he's in
from
jail.
Will B.
From Will B. Go ahead.
Yeah, wants to know what discretion the judge has to push proceeding for a specific trial date.
It's totally his discretion, is it not, Matt?
It is. He says that at the end of the hearing, he says that he would like to see if they could get a little closer on discovery before he sets a trial date one way or another. Because, on January 9th, we had the defense making an 11th supplemental request for discovery. So from the defense perspective, the discovery is not completed. Now, we know the state asked for a trial in the summer of this year. So maybe the state felt like they were ready. But I just think that the judge was wanting to be very careful about saying, yes, the trial will be in the summer of 2025. I think he wants to see how the parties are doing with discovery, whether the defense is going to file any more motions to compel discovery. And I believe that at some point there probably will be a new scheduling order that will set the parties on a course to finish discovery. I mean, he's not going to just let this go on forever, but we have to realize that the quadruple homicide, we potentially do have hundreds of witnesses. When you consider you have fact witnesses, law enforcement witnesses, forensic pathologist, medical examiner. I mean, there could be hundreds of witnesses, and both sides may not even know who all of the witnesses are at this point. So it is only within his discretion to finally say, okay, this is going to set a trial date, and it's not moving, and here's our pre-trial motions deadline, here's the discovery deadline, and this is what it's going to be. I have judges do that in my cases routinely because they want the case to be final. They want finality. Everybody understands this is a case that's very difficult for the community, for the families. He wants us to move forward, and I think by asking what he could do to assist the process lets me know that he's not interested in delay. He wants the case to move forward. But if even the state is saying, hey, Judge, it could be the summer of 2025, then I think he's going to take that seriously.
Right. I sense that he does not want to delay in this case any more than it already has been. But he may not have a choice because it's a DP case. And here's where I may differ from some. And no matter what, he's going to get appeals because it's a DP case. So now moving forward upon conviction, let's say he does hypothetically get convicted and the jury recommends the death penalty. Who moves forward with the automatic appeal? Does that come from the state automatically, or does that come from the defense automatically? Does the state do that automatically, Matt, in Idaho, or do you know?
Great question. For Idaho, I do not know.
I'm pretty sure here the state does it automatically in Florida, but
In Florida, it does.
I'd have to double check. That's how it used to be.
Florida does.
It does. So, but states vary. They're different, and some states, the jury doesn't get to make that decision. The judge does. So, as far as penalty phase, when it comes to DP. So, I'm pretty sure in Idaho, the jury does, though, if I remember right. When I looked it up a while ago. But we'll
I've
move
got
right
two
along.
questions for Matt. One from
Go ahead.
Grizzly Bear and Grizzly Bears, I'm sorry. And the other one's from Tigger.
Okay.
It's right here. It says he wants to know, does the judge want to go to trial so fast? Is there any gain to doing that?
Matt, did you hear that?
I did.
So basically, he's asking, is there what's the advantage of going to trial this quickly? Well, in my opinion, it's not very quick. I mean, but it's for the community more than anything, in my opinion, for the victims.
I think it's
Go over the victims. Go over the victims, Matt.
I think it's considerations of the victims' families.
You're cutting out.
I think it's considerations of the community and also consideration of the victims' families.
Right. And they talk about that in this hearing. And what was the other question?
And Tigger would like to know, let me see here, I'm sorry.
Was Tigger before that or after that?
Tigger's busy. No, it's way down here. Let me see. Would like to know how do you think the defense team is and how many paralegals and researchers are helping out?
Oh, Matt, that's a loaded question right there. I don't even know if Matt,
the way it really is.
On a complex case like this. Go ahead, Matt. What do you think?
There is no telling. Yeah, there is no telling, no way to know. I mean, I don't know what the budget allocation from the legislature is like for the prosecution, the prosecutor's office, compared to the public defender department. Friends of mine who are public defenders have always talked about the disparity in the resources, about how the prosecutors and the district attorneys have so many more resources, mostly investigators, but even sometimes attorneys and paralegals. But I wouldn't be surprised at all if they're pooling resources from other offices around the state. I mean,
right.
It might be all hands on deck for a case like this.
Right. And I think it is. She actually says that this is our primary focus. This is this office's primary focus. She keeps saying that, and Taylor does. And for those that when you heard Matt speak of investigators, the state attorney's office has investigators on both the prosecution side and the defense side. And a lot of the times they're retired. Officers will retire from the police department and then I go to the SAO and they double dip and they just basically pick up their same job, but they're working for the state attorney's office doing an investigation on a case, seeking out more witnesses, getting more discovery, looking for answers that weren't found in the initial investigation. A lot of times the state attorney investigators will find the answers to those questions.
I've got one for you, Matt. If you wouldn't mind, I'll field it and you tell me if I'm right. This is from Art Reese. Says, could the defense delay to keep BK in the relatively nice conditions in jail rather than dire conditions of a prison if convicted. My answer to that is prison is so much better than any jail. And if they want to set it off, it's just because they want distance between the event and trial to, numb the pain a little bit. Am I correct?
I say you're correct, because state facilities are way more presentable for or accommodating for a prisoner than a county facility is. I don't think people realize that, but you don't want to go to county jail. You don't want to stay in county jail.
People
You want to
fight to
be
get
in
out
a
of
state.
county jail.
You want to be in a state facility. So, Matt, I don't know. Do you agree with that?
It's possible. Possible, but I actually think that part of the issue with wanting more time is that if they're, first of all, there's the genealogy issue, right? So Anne mentioned during the hearing, the idea of exploring, generations of his family. So what went off in my mind there was, looking into the genetic genealogy angle. But another thing too is if you're representing a client in a capital case, you want to explore all potential defenses and any angle that you possibly can use, including a mental health defense or a mental health approach, because he doesn't have the insanity defense available to him in Idaho. It hasn't been available in Idaho since 1982. So I would say if you're representing a defendant faced with the death penalty, rushing to trial is not necessarily something that you want to do.
Right. So they're going to bite all the time they can. Absolutely. So let's hit on that insanity portion again, because we know some states, of course, have an insanity defense. We have an insanity. A lot of states have insanity defenses. Idaho does not. But when she talks about having to delve into his past, so let's say perhaps they can find something that happened during his childhood that may have had a psychological effect on him, they would be able to present that to a jury and they consider it, but not as part of an insanity, just as part of a mitigating circumstance. Am I right there?
Well, the Idaho statutes, and it's 18-207 for anyone wanting to look, and it outlines how you can use mental health as a relevant issue in a case. And what it goes to is his state of mind. The technical Latin term for it is mens rea. And the statute says that if you present, you can use expert testimony to essentially present evidence that a defendant would not have been capable of forming the state of mind necessary for a particular offense. So, in other words, Bryan wasn't capable of forming the intent necessary for willful, deliberate, and premeditated murder, which is first degree. And there's a corresponding jury instruction. If you look in the criminal jury instruction, I think it's 1506. It tells you, what the result of successfully using this approach could be, and that would be a not guilty verdict. So I would suggest reading the statute first, and then the jury instruction, and you understand how it can work. And I'm not saying the defense is going to do that in this case, but if some of the reports that we've heard about Bryan are true, then I think a mental health issue is certainly a possibility. I'll just say it that way. So
I think. Go ahead. I'm sorry. Go ahead.
So insanity. You're talking about insanity really as an affirmative defense to a charge. So the Idaho statute doesn't really frame it that way, but a defendant in Idaho can use mental health as an assist in their defense.
Right. Well, I feel like she's kind of, you know how Ann Taylor plays on words, right? Continually. In her motions, she plays on words like knife sheath was placed, things like that. Her partner in crime there played on words. Where the state just wants to kill this guy. And she just, I think, made kind of in trying to lay the foundation for needing more time and delving into his past. She's basically saying she's got to come up with a defense for this guy because he's mental and he did it. I think that was a tactful mistake, her doing that. I don't think she should have said that because everyone can hear it now. And what I hear is we got to come up with something. We got to find something in this guy's past to make it okay. You know what I mean? That's just my thought on it.
It may have been best to simply go with the discovery angle, and we have so much discovery. We don't have the resources. There's no way we could possibly be ready for trial in summer of 2024. We think it's more like summer of 2025. But, I guarantee you that Bill Thompson and the attorneys from the Attorney General's office that are assisting, they have to know that on some level, mental health is probably going to be an issue in this case because they've already seen the discovery. And if they didn't know, then I think she certainly previewed it in some way. And, if you're the defense, you want all the time in the world to look for affirmative defenses and anything else that, you could make an issue of in the trial. But strategically, if I were the defense, I probably wouldn't have outlined it and previewed it in that way.
Yeah, I think that was a mistake on her part. She needs to
Hey,
think
John?
before she speaks sometimes. Yeah.
Sportsy Girl has a question about the PCA. She says she really wants to know if the PCA is really a PCA or is it just an exhibit, as it states at the top, Exhibit A. Have you seen this before? And is a PCA is labeled Exhibit A before that a PCA is labeled Exhibit A? Did I say that right, Sportsy Girl? You see it?
Are you following that, Matt? You know what she's saying?
Yeah,
people are out there labeling the PCA as an exhibit.
Well,
it's a PCA. It's not. I mean, yeah, of course it's an exhibit, but it's a PCA.
One of the ways that you can use a PCAA at trial is to impeach witness testimony. If you see a prior inconsistent statement, one of the issues you run into with a PCA also is if you don't call a particular witness at trial, you could run into a hearsay problem. But
right.
I think cross-examination of the law enforcement witnesses, I think is an area where I've seen defense attorneys try to impeach their credibility and find the prior inconsistent statements.
And you know what I find? One problem I have with the PCA in a way, what he wrote in there was the frozen shot phase. Now he put that in quotations. Why? And I've talked about this before. If it's in quotations, then she said it. Now, if she didn't say it and he put it in quotations, he's going to have to answer for that because that's an opinion. And his job is not to put opinions in a PCA. It's just the facts. And if for whatever reason he put that in there because that's what he believed she was in, there's a problem with that. Now, can he be impeached for that? I guess he could, but it's not gonna cost him the case. But he's gonna get his ass handed to him if he put that in there and that wasn't a quote from her.
Well, and I think with Dylan as a trial witness, we're gonna find out.
We're gonna because we're gonna put her on the stand. You're absolutely right.
She's gonna be asked, is is this exactly what you said? Did you say this? Did you say something similar to it? Or did you describe what you were seeing and then, law enforcement embellished? And I've always been kind of confounded by, the frozen shock face thing and the fact that it was in quotes. That initially made me think that it's something that she actually said, and she said it that way. But we're a year out. I'm now not sure that's the case.
Yeah, and it very well. I mean, she is in college. She could have just got out of a psych class, and maybe she does. Maybe she's versed on the frozen shock phase. I don't know what her background is, but maybe. I mean, it's plausible, but under normal circumstances, I would find it highly unlikely that a victim would say, "I was in frozen shock phase." But I could see, and I've been around officers like this inexperienced detective who wrote a PCA that had way too much, in my opinion, information in it, that he would, like you just said, admonish on it and came up with that theory in his own mind and made that mistake of actually putting an opinion in there and not a fact. And that could hurt him, but it's not going to cost the case, but he could get his butt handed. It'll be a lesson learned for him, I'm sure.
Well, and also,
I have a good question from Kathy Jean about DNA.
Let Matt go ahead and finish what you were going to say, and then
sure.
we'll take
No, I mean, just something else about the PCA being, labeled as an exhibit. So, if you're applying for a warrant, you're going to have attachments and trial exhibits. There's no way that the state or the defense have, probably labeled any exhibits at this point. I'd be very surprised if they have, but I think that you can't think of the PCA at this point as a trial exhibit. You need to think of it more, as an exhibit in a application for a warrant.
I think what has happened there is there's another creator out there that has some law enforcement experience, and he referred to it as an exhibit, and I disagree with him. Yeah. I concur with what you're saying exactly. Okay, go ahead, Stacy. What was the question?
Hey, Matt, this is from Kathy Jean. She'd like to know why wouldn't they have tried to get Bryan's DNA either out of the classroom or as trash in Washington, and why did they leave him open to see how easy it is to get BK? His DNA could have been from his doorknob or his car. I hope I said that correctly.
Well, first of all, we don't know that they didn't do that. See, that herein lies the problem. We don't know what they have. We don't know what they did. I would submit that they did do all of that. I would submit that they did garbology in his office. I would submit that they did garbology at his apartment. I would submit that they were probably surveilling him. Many don't believe that, but I believe at the point that vehicle hit the media and that officer or that campus cop saw that vehicle, they were on him. I think they were on him a lot quicker than most people realize. I believe they were surveilling him, and I believe they probably did pull garbology at some point. We'll have to wait till trial when discovery comes out, but I believe that they were on him pretty quick. That's why that car that was in where was that other White launcher that was wrecked on the side of the road?
I was in Oregon. Eugene. Yeah.
That's why I said immediately, I'm like, that's not the car. Yes, it is.
Yeah,
yes, it
that's
is.
when they were implying that like there was another group of people involved.
Yeah,
like
and I said, there's no way that's the car. First of all, there's too many too many factors there that car would be bagged and secured and gone. It's been there for days. It was wrecked. It's totaled, and they're waiting on a rotation record to pick it up. And the reason why they're not on it is because they know what car they're on. They're already surveilling it, and bam, within days they had them. So anyway, Matt, you have anything to say to that? Go ahead.
Well, I agree that we don't know that they didn't do it. I mean, I think we still we know such a small percentage of, what the investigation actually is that, that we don't know. And I mean, when the case first started, I mean, I sort of thought, well, how is it that they even let him, get out of the state, headed back across the country, to Pennsylvania. But then I started thinking about it as like, you don't want to mess a case like this up if you're
Right.
law enforcement. You want to make sure that you have the probable cause necessary to get a warrant. But I agree with you, John, that they had eyes on him.
Yeah.
I think from pretty early on, I'm guessing it was probably a tip, but we also
Yeah.
know that the Washington State University Police, it seems like that officer, jumped into action and had an identity of his car.
Yeah, he was on it. There's a sticker. All universities, all residents have to have a sticker. So he probably walked right up to it, had all the intel, everything they needed, and he's a hero. So I think they were on it relatively quick. At the point where he gets on he solicits the media to ask for help in finding this car. I don't think you're talking about 8 miles away. People walking by this car every day. That's why I'm also not buying the initiated stops on the way to Pennsylvania being totally drug enforcement related. There's no way I was on the drug enforcement task force. I mean, getting stopped twice within 10 minutes. I think they were surveilling him. I think that the surveillance had to stop and get gas and lost him, and they had to get him pulled over or whatever. I don't know what happened, but I think they pulled him over to buy time so they could get back on him, or just to feel him out. I'm not buying that even though they're saying that they weren't solicited by anybody to pull him over, I don't believe that. They're allowed to lie. They don't need to tell us what they did. That's just my opinion, though.
Bella has a question.
Okay.
She would like to know. Let me see here. Hold on one second. I just lost it for a second. Did Dylan and Bethany already testify or submit any kind of testimony to the grand jury trial?
Well, we don't know. We do know that Ann Taylor attempted to issue a subpoena for Bethany. Bethany was in Nevada or Nevada, depending on who you
Vegas, wherever there.
Right. Yeah, exactly. And so her attorney filed a motion to quash that subpoena, and then the defense agreed to an interview. Now, did that interview ever happen? When did it take place? We simply don't know. But I mean, it's obvious that law enforcement interviewed them probably multiple hours over many different interviews.
Right. And I'm glad you're using the word interview, because some of these creators want to use the word interrogate. You don't interrogate witnesses. You interview witnesses. Now it could turn into an interrogation, but we've had creators out there saying they should have put them both in handcuffs and take them down there and thrown them in a cell and let them roast.
The best was put them in the Goncalves kitchen and throw them a sandwich once in a while.
Yeah. It's unbelievable.
I mean,
that was
custodial interrogation.
We know who said that.
Yeah, I know.
Interrogation is a term of art. It happens at a certain point in time, and you don't for somebody who's has from all we know always been treated as a crime victim, which they are. Right. Interview is the proper term.
Exactly.
Coco Bradley has a great question.
Go ahead. Let's do one more, and then we got to get back on this because he's only got so much time. You got three hearings tomorrow, right? I don't want to keep you up too late.
Wow.
Three hearings. Matt. 3 hearings tomorrow and 5 this week total. Yeah.
So you let me know as long as you're not going to hurt anybody's feelings if you got to go, Matt. So,
okay.
What's the question?
This was from Coco Bradley. She says, if Bryan was wanting back there to be exonerated, why wouldn't he give them DNA without a court order some channels using Dylan needs to stop this stupidity for grifting on money from misery. Wants to know if Bryan was wanting to get back there to be exonerated, why would he give them DNA without a court order?
Well, he just waived his right to extradition, correct, Matt?
Correct.
That has nothing to do with that.
Well,
You know,
well, and
go ahead.
also exoneration, I've thought about this too, is that he may have, used the term, if he in fact said this, used the term exoneration, meaning it to be something else, right? I mean, because it's got a certain connotation. He could have even as easily meant eager to be found not guilty. I mean, for all we know, but his rights, his Fifth and Sixth Amendment rights were invoked almost very soon after the arrest, and so I mean, we don't know when all the DNA swabs took place, when all the DNA collection took place. So I think that one is tough to answer. But when he said exonerate, he could have meant eager to be found not guilty, for all we know.
Exactly, that's what I believe. Let's get back and let's get this to trial, and I'll be exonerated. Actually, he probably was implying that a hearing would exonerate him, and yeah.
Willow
totally
has
agree.
a good one.
Go ahead, one more.
She would like to know if visual snow is part of his. Could they use that as part of his defense?
That could be part of his psyche, correct, Matt?
I believe it's possible, yes.
Because that could drive. It's kind of like having TMJ. I mean, things like that can get to you, So visual snow is. I read up about it a little bit in the beginning. Got a good memory. It's just short, but it could definitely it could wear on you for sure. All right, let's get back to the. Go ahead, Matt.
So, and they're going to need, in reading the statute, you see that the defense has to provide notice to the state if it intends to introduce expert testimony related to a mental health issue, that relates to an element of a crime. They have to put the state on notice.
Right,
and I mean,
yeah,
and I don't want to.
Go ahead. Sorry.
And I don't want to try to read the minds of the legislature, but I think that probably, since insanity has not been a defense in Idaho, an affirmative defense since 1982, you want to give the state an opportunity to and enough of an advance to consult with its own expert, to rebut that testimony.
That's exactly what I was going to say. Yep, exactly. And that takes what? Time. So therein lies, could this be delayed longer? Well, if she's laying the foundation that's the direction that they're going to go, I mean, it's a compelling argument, is it not? To get more time. I mean,
Right. Well, when you're dealing with multiple psychological evaluations, psychiatric evaluations and reports, those things do take time. And in a capital case, you're going to explore all affirmative defenses and anything that you can use at trial, to assist your client. And if if you have something like a mental health issue that could essentially, negate the state of mind element for, one of these charges, then if you're a defense attorney, you're not doing your job unless you fully explore those things. I mean, you risk appellate issues. You don't want an ineffective assistance of counsel appeal, but I always tell people that ineffective assistance of counsel appeals don't mean the assistance of ineffective counsel.
Right. Yeah, and
I have a question for Jeff H.
For Jeff H.
Yeah.
From Jeff H. You mean?
Yep, from Jeff H. Our runaway Mod. Wants to know if a frozen shock face means nothing more than Dylan was shocked that the guy walked right past her as if she was invisible. No reaction to her presence.
We don't know until we get her on the stand and ask her. You know, I mean, I don't know if you got any more to add to that, Matt.
I don't think we're going to know until we have the law enforcement officer who heard that statement testify, and until we have Dylan testify.
Right. Yeah, that's my stance on that, Jeff. And also going back to Ann Taylor and the whole, so, and correct me if I'm wrong, which I don't think I am, but if you're in a capital case and it's a DP case, and it comes to fruition that this evidence is overwhelming, her main objective at that point is to get him off the DP. So for her to let the cat out of the bag as to what she's doing right now, digging into his past, again, I have to say it, Matt, I think that was a tactful mistake on her part. And that's kind of letting us all know that there's way more out there, and it's not looking good for Mr. Kohlberger. So she's going to be diving down those holes of his past and trying to get sympathy and empathy from the jurors to avoid the DP.
Well, if the genealogy, played a part in her arguments, then certainly, the knife sheath is a huge, piece of evidence, for the state. So we have that, but also if she's thinking, of the possibility of a conviction and then mitigation during the penalty phase, then
Right.
All of these, his entire history from childhood up until this point, and
The heroin addiction.
yeah, and the history of family members, any environmental things that that could have affected him,
Right.
those all become relevant. But again, I think it was just part of the her overall argument that, Judge, we need more time, and there's no possible way that that we can be ready, when the state says that they're ready. We need more time. I think it's an overall picture that she was trying to paint for the court.
Right. All right, here we go. We're going to
I
keep going with
have
this.
two
Let's
questions from our Quizly girl.
Hold on. Let's roll with this a little bit longer, and then we'll pick up on some
Okay.
questions because I don't want to lose Matt here.
Okay.
Excuse me. Well, first of all, this is a reconsideration of the order relating to dismissing the indictment, whether or not the standard for proof on a grand jury is probable cause or beyond reasonable doubt. I don't think we've done anything wrong about that. That decision was put out quite a while ago. It's rooted in well-settled law. And I think it was correct. Supreme Court, I guess, could turn that around, but that is doubtful in my opinion. We went through Idaho Constitution, statutes, case law, criminal laws, and really common sense. So I feel quite confident that that was a correct decision. So that established that it is well established that the standard of proof for indictment in the grand jury is probable cause, not beyond a reasonable doubt, which is the standard for trial. So putting that aside, now we get to this permission to appeal under Rule 12. So, excuse me, let me just get this in front of me.
All right, here's your stuff.
So, the criteria for permission to appeal, this is in Rule 12 of the Idaho Appellate Rules. First of all, it's very, very rare in case law for such an appeal going to the Supreme Court. It does happen, but it is rare. And the court has established this criteria. And I'll just read this part of this. The issue needs to involve a controlling question of law under Rule 12. So, excuse me, let me just get this in front of me. So, the criteria for permission to appeal, this is in Rule 12 of the Idaho Appellate Rules. First of all, it's very, very rare in case law for such an appeal going to the Supreme Court. It does happen, but it is rare. And the court has established this criteria. And I'll just read this part of this. The issue needs to involve a controlling question of law as to which there is substantial grounds for difference of opinion. Again, in my opinion, and based in all the law in Idaho that I've found, is that there's not a difference of opinion about what the standard for the grand jury is. So the defense is making that argument. I respect that. I don't agree with that, but that's where this is. I don't see a difference of opinion throughout the state about what the standard is for grand jury determining an indictment. But this also has a second component. And this is something that Mr. Nye really focused on, is which an immediate appeal from the order may materially advance the orderly resolution of the litigation. And I'm very concerned about delay. And I think that if we send this to the Supreme Court, that it's going to add delay. Mr. Logston is correct. I mean, this is a complicated case. It could take a long time, longer than any of us want. But I think that would add additional delay. And as I said, I'm already concerned about that. We're over a year. Could be another year. I'll just let you all know that.
Mhm.
Now, even if the Supreme Court takes up this appeal, or I deny it, I'm going to deny the permissive nature. Yes. If I deny it, the Supreme Court can still pick up the appeal.
So see, that's what I was telling everybody before, Matt. You would agree, I'm sure. Doesn't matter. It's going to be up for appeal anyway. But Matt, you probably have something to add to that. So he has to address that, though, correct? He has to address it right now. He can't just not do anything about the request, so he has to address it.
I think, he's explaining to the defense that you didn't meet the elements, the requirements of Rule 12 for permissive interlocutory appeal, and I think that they probably chose to do that because it's a procedure that's available to them. They thought that they had an issue that was interesting enough to ask for permission to do so, even though 30 years of case law didn't support the notion that the standard at grand jury is what the defense claimed that it was. So I think he's sort of reminding them that, look, the Supreme Court could still decide to take up this issue. Although I got to be honest, looking at the case law, I can't imagine that they actually do pick that up as an issue on appeal.
Have you ever heard of a Supreme Court, a grand jury being overturned? I haven't. I'm not saying that it doesn't exist, but I've never heard of it.
Not that I can recall right now. I mean, it's certainly possible. I believe that you had a defect in the grand jury process that's so significant that it that an indictment could be overturned on appeal. But the issue before the court was the standard used at the grand jury level, and the defense position was just not supported by the case law.
The only thing that I could think of, and I'm not saying it does exist, but would be like a RICO case from back in the mafia days, the 50s, maybe some kind of a pool tampering or something like that to get it overturned. But I don't see that happening. But hey, he's laying it out right there. I mean, it's very unusual.
Yeah, well, when you think of what are the things that could get a grand jury indictment overturned, so you think of a defect, a problem with the grand juror selection process,
Right.
the questionnaire.
What's she shooting for? She's
right.
Yeah.
They also raised prosecutorial misconduct, I believe, and there were separate motions, to dismiss. And I think what they were probably going at there is claiming that the state had exculpatory material that they did not present to the grand jury, and they are required, if they know of substantial exculpatory evidence. And I believe the rule actually uses the word it's substantial. That's probably what they're shooting at there.
Right, exactly. All right, let's move on.
All right.
That's up to them.
I've got a question from
They do look at what
PKC.
district judge's
Hold on a second.
opinion may have some bearing on that. I hope so. But they could still overturn the orders of this court denying the motions to dismiss the indictment. And they could dismiss the indictment. What would happen then? Okay, is this going to really materially advance the orderly resolution of the litigation? The state.
No. What do you think, Matt?
Well, they're going to end up in trial anyway. I believe it was Mr. Nye who said, if we're being honest with ourselves, we know that this is probably going to trial. And I think that's
Right.
what he's alluding to there, that we're gonna end up in the same exact place we're in right now.
So we're just wasting time entertaining this, and let's move forward and get this show on the road, is what he's saying.
You could just refile it, as Mr. Nye said. So that's significantly more delay.
Yeah, so basically everyone, what he's saying there is, okay, so we throw out the grand jury. All the state's going to do is just turn around and refile it. So then we start all over again. Do you honestly think that by throwing out, is the defense's contention that we throw out the grand jury, that this case is going to get dismissed? Is that what they're thinking, Matt? Because there's no way that would happen on a capital case like this.
Correct. I mean, he's still under arrest. They have to proceed with.
They'd have to do a bond hearing again and everything. They'd have to redo it all.
Yeah,
Right.
and the case is still moving forward, and I think the judge believes that they will end up in the exact same place where they are now, where you go through a preliminary hearing, probable cause is found, and the case is bound over again for trial, and so because the judge is so concerned about delay and as Bill Thompson says later, the impact on the community, on the victims' families, this is why he's denying the permissive interlocutory appeal.
Right. Moot point. But you know what? I always say, don't hate the player, hate the game. She's got to do this, because what could Bryan do if Bryan suggested she do this, which he very well may have, and she didn't do it? Then what does he have grounds for at the end?
Yep.
Misrepresentation and insufficient, representation. Correct, Matt?
Yeah, I mean, ineffective assistance of counsel appeals are very, very tough. It's a tough case to make. But if you're an experienced defense attorney, which we know Ann Taylor is, you are looking at every possible strategy available, to effectively represent your client. But so, sometimes I think that people, late in the day in a law firm or in a DA's office or public defender, they start getting creative and start thinking, what's something novel we could try, and
Right.
they came up with this, and as we see it, it's not working.
So she's not only checking all the boxes and some, basically is what she's doing.
Yes.
All right, here we go.
All right, this question comes from KC. Wants to know if the defense can lie in court on court documents, no DNA, no DNA in the car, the apartment, the house, unknown DNA profiles in the house. Just wants to know, can the defense lie about those things?
Well, when you sign a pleading that's filed with the court, you are making you're attesting that the pleading has a basis in fact and law, in terms of what's in the pleading, and that's for pleadings that are filed. If you make a misrepresentation in a hearing, and you say it, you have reason to believe that it's not true, then you have a whole host of other issues with professional conduct. So I guess the technical answer to that is no.
But here's another direction we can go with that. If she doesn't know and doesn't have the evidence that she's asking for, she can say she doesn't have it and it doesn't exist. So let's say she's waiting, she's waiting for more DNA, or she's waiting for some piece of evidence that she knows is there and that we all are speculating that they have. She can say, well, we don't have it. They don't have it. Well, because she doesn't have it yet, because whatever entity is processing that hasn't produced it yet in discovery. So in my opinion, Matt, it's just like the cops can lie, during an investigation. She could actually send that subliminal out there to the public that they don't have this, they don't have that, they don't have this because we don't have it, so they mustn't have it. But really, they just don't have it because they don't have all discovery yet. That's the roundabout way that I would look at it too, as a possibility.
I agree.
Is that a tack that they could use? Absolutely. And remember, everyone needs to remember, there's eyes all over the world watching this case. So every time Ann Taylor can get behind a microphone and a camera, she's going to send a message subliminally out to all of us, leading us to believe that there's some sort of nefarious garbage going on, and her client is innocent. That's her job, to cast doubt.
I have
She
a
wants to.
question.
She wants to inevitably affect the jury pool. That's what she wants to do. Am I right, Matt? Or do you agree with that?
Well, the more, obviously, the more information that is in the public sphere, and the gag order, gives us, we have very limited information. It could certainly, I think at some level have an impact on potential jurors, even if they don't want to admit that it does.
Right.
So I agree with you that if an attorney doesn't know something one way or another, if they have a good faith reason to believe something, and and it's in a pleading, then I think there are no issues. It's when you know something and say the opposite that
Exactly.
you have a problem.
Exactly.
I have a
So
question.
go ahead.
What legal precedent do victims or people that are named in crimes, or satellite people that are in crimes, what can they do when certain channels build cases against them and they're not even suspects?
You mean like a civilly?
Yeah, I
What was your-
mean, the people that are getting cases built against them on various channels for over a year, do they have any type of thing to stand on?
Matt, you know what's been said out here. Would you represent Dylan right now in a slander case or libel or a case where you have some of these creators that have said the outrageous things and the deep pockets that some of these people have? Would you represent Dylan?
Well, when you say something, as fact instead of as opinion, that's where you start to, get into the libel and slander category. And I mean, certainly, when third persons hear that, which YouTube channels have, thousands and thousands of viewers, then you certainly have the statements being going out to the ether, right? And so
Right.
I've heard things said which kind of, in my opinion, cross over from opinion and just into straight up facts territory. Let's just say this. I mean, I'd certainly be willing to consult with someone in her position.
He's consulted with
I
me.
have a follow-up question
Just
now.
saying, he's consulted with me, y'all. Just so you know,
Right.
Matt's a good attorney.
Go ahead.
All right, here we go.
There's some other, actually, this is in a case law, Idaho versus Todd, where it's an old case, 1983, but the court also considers other factors, including the impact of the immediate appeal upon the parties, the effect of the delay of proceedings in the district court pending the appeal, the likelihood or possibility of second appeal after judgment is finally entered by the district court, and the case workload of the appellate courts. But it finishes with an appeal must be exceptional, seeking of that appeal. Because the Supreme Court doesn't broaden the appeals, which may be taken as a matter of right under Rule 11. So, in my opinion, I do not find that the criteria is satisfied for a permissive appeal. There's no controlling question of law where there is substantial grounds for difference of opinion. The law is settled as far as I'm concerned, and there's no difference that I'm aware of. I also do not see how the appeal could advance the case. To the contrary, it would stall the process when we really need to move forward. So I'm denying the permission for appeal, obviously denying the motion to reconsider. And with that, I think we are ready to go to setting a trial, or at least a schedule order. So anything else about this issue before we go to that? Ms. Taylor?
No, Your Honor, thank you.
Mr. Thompson?
No, sir.
Do you want to go first, Mr. Thompson, about the state's position on scheduling?
Yes, sir. I'd be happy to. And to start, Mr. Lodson said something that I think needs to be addressed. He makes the allegation the state is trying to kill someone here, and frankly, I find that offensive. What the state is trying to do is to enforce the law that our legislature has put in place. It says, in cases such as this, with facts like this, a jury is entitled to decide not only guilt, but potential fulfillment. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying to kill someone is just simply appealing to raw emotion, and it has no place in this court. We would ask that that not be allowed any further.
And I want to say, Thompson has had DP cases before, and he's taken the DP off the table. I just want everybody to know that.
Now, as to the trial, Ms. Nyer already noted that we have a variety of competing interests here. We have certainly the defendant's right to a speedy trial, which he has waived at this point. There are also interests of the state itself, and I think even more importantly, the victims and the families of the victims in this case to a timely disposition of this case. Granted, this is a complicated case. It is a very serious case, and a lot of effort needs to rightly be put into it to make sure that the case is handled correctly. At the same time, we need to also balance the need to move forward in a constructive, productive fashion. When the state filed our motion asking for a scheduling order and trial date, which was a little bit over a month ago, we proposed the summer of this year. And at that time, at this time right now, we believe that we can be prepared for trial summer of this year. We realize defense has factors and considerations they want you, Your Honor, to take into account, and certainly we want to afford them that opportunity. I will say, though, that, and that we touched on this in our motion, in our request for the scheduling order, that given the nature of this case, if we are going to try this case effectively with minimal unnecessary harm or disruption to our community, it should be done during the summertime. And I say that because right across the street there is Moscow High School that shares parking all around the courthouse with everybody else who's going to have an interest in this case and being here. And we've already encountered the conflict between those interests. We can't sustain that for weeks and weeks on end. That's just not fair to the students. It's not fair to the school district. It's not fair to the media. It's not fair to anybody. The other factor is, as Your Honor knows, we have two universities, part of our community. And during the academic year, we have graduations, we have numerous sporting events and other university-related events that essentially consume every available hotel or motel room within miles. This case is going to involve bringing in people from out of state, numerous witnesses from out of state who will have to be put up in lodge. And we would submit that that's going to be unnecessarily complicated if trial occurs while the universities are in session. So those are the considerations that we have, Your Honor. As I said, we filed this last month at that time, and as we stand here today, we believe that we could be ready for trial this summer. Thank you, sir.
Thank you, Mr.
All right, so I'm going to interject on this one because I think that he made a huge mistake there, because you're going to hear she's going to allude to the fact that she's going to be asking for a change of venue. He just supported a reason why they should potentially get a change of venue. Okay. He just supported what she's going to say. He should not have said anything about the effect that it's going to have on the community, the college, I mean, the high school, the university, because the high school is right there next to the courthouse. They're not going to have parking for the kids. The reason why this needs to happen in the summertime is they're on break, blah, 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 blah. So basically, he's given her more ammo to support a change of venue to a less populated or an area that's not by a school. They would typically want a big city, which would, you know, for lack of a better term, be a little more liberal and against the death penalty. Matt, what do you think?
Well, if you're looking to file a motion to transfer venue in a capital case, you know, I think one of the biggest considerations would be, you know, a potential jury pool that you think, you know, you may have jurors that are not likely to vote in favor of the death penalty. So, not exactly
And that
sure.
would be a bigger city typically, because your rural areas are more, let's just face it, more conservative, and your bigger cities are generally not.
Yeah, and you're going to want a larger, you know, population, you know, as well.
Right.
But I do think it's a major consideration, you know, for the defense. I mean, I always suspected that they would file a motion to transfer venue. I just didn't know at what point, and now, you know, she's announced that they do intend to do that.
Do you think that he made a mistake in doing what he just did and bringing that up? Because to me, it kind of supports what she's going to ask for. And if she's smart, she'll use that. She's not going to use it here. We don't hear her use it and say, well, you know, Thomas just actually said, you know, that's going to cause, you know, problems for the community. So we need to move the venue. But I bet she comes back with it in a written response.
I don't think I would have said that if I were him.
Yeah. Yeah, I think that was a huge mistake on his part. Moving right along.
I've got 2 questions lined up for Matt.
Your Honor, I received Mr. Thompson's motion for a scheduling order, and I had the opportunity to meet with him and talk with him and Ms. Jennings about that. So it is no surprise to the prosecution that we do not believe a summer of 2024 trial is realistic in any way. Understanding the state's concerns, if a trial were to happen in Latah County, we would suggest looking at summer of 2025. However, counsel and the court's aware that our intention is to file a motion for change of venue. That hasn't been filed yet because we're not ready to have that heard yet. There's work that has to be done to present to the court and counsel in support of that. So that's just for the court's information. Your Honor, that in the state's scheduling order, it asks the court for various things. And a lot of those we don't have disagreement with. We think they're appropriate. And in fact, they were things that were covered by the court in the court's original scheduling order. As the court and counsel recalls, last fall, we had not made the choice to waive speedy trial. And so the court did a scheduling order at that time. It wasn't but a few days later that we'd had enough time to discuss that. And Mr. Koberger decided to waive his speedy trial, and the court vacated that order. So I'm familiar with what the court likes to put out there as far as a scheduling order, and I don't think there's a problem with that. I would want to inform the court that I do not believe this is a 6-week trial. I believe this is more like a 12 to 15-week trial. This is, as everybody said today, a very complicated case. And I want to talk a little bit about what drives both our request no sooner than summer of 2025. And I say that with fear, Your Honor. There are a lot of things that we have to still do. I want the court and counsel to know that we haven't sat around waiting for a scheduling conference to begin doing those things. We have been on this case and active and seeking discovery and reviewing discovery, meeting with experts and working the case since the day we were assigned this case. So with that said, there's still plenty to do. And I want to talk a little bit specifically about that. In a case where there is the potential for a death penalty, we're looking at 2 tracks of trial. We're looking at the innocence phase, where there's tons of witnesses and a lot of things that happen. And if there is a guilty verdict, we immediately go to a sentencing phase. That's up to the jury what happens there, but both parties have to be ready to proceed forward. So we don't get the luxury of focusing on our case, the state's investigation, our own investigation solely. We focus on that. We are working on that, but we are required to begin our mitigation case. That's what it's called, the penalty case. We are to put on mitigation. We are guided by the ABA standards, American Bar Association standards, in capital cases. That's what this is. A death penalty case is a capital case, and we're guided by those standards. And they tell us that as attorneys, we must investigate every aspect of the case in the innocence phase. We must meet with our client regularly, which we do. We must engage in experts and understand the issues that are coming, which we are. The American Bar Association guidelines in capital cases say we must hire a mitigator, and there must be a mitigation investigation. We hired a mitigator, probably one of the very first people we contacted. And so that has been ongoing for 13 months almost as well. We have not been sitting back and waiting. Your Honor, in this case, the complexities are that there are special areas of focus. And when we get to trial, counsel for the state will put on experts to educate the jury on specific areas of focus, as will we. And it takes a while to get all of that done. In addition to that, the court knows everything is recorded. There's digital prints all over the place. And so we have a lot of records that we have to go through. I know that the court has heard about 51 terabytes of information that we've received. And I want to tell you what that means. Ms. Massa found a statistic for me, and I want to tell you how much 51 terabytes of data is. And she found that. She was looking at Dropbox.com, and 51 terabytes of our discovery, to put it in perspective, 1 terabyte can hold 250,000 pictures. 1 terabyte, and we have 51 of those. Or 500 hours of high definition video, and we just have one of those. So 500 hours times 51, or 6.5 million document pages. And that's equal to 1,300 filing cabinets.
Yeah, high definition video. What about 3D video? How many terabytes do you think all those 3D renditions that they've been taking of the crime scene have taken up? She's blowing this way out of proportion, people. I'm telling you right now, the state can move on what they have. They're reviewing it as they get it. She's playing games here. I don't think it's an overwhelming amount of information, yes, but she's blowing it up to be something that it's not, in my opinion. I don't know what you feel, Matt, but I don't think it's as bad as she's making it seem. I think a lot of those terabytes are 3D video, things like that are taking up a lot of that stuff. What do you think?
Well, it could have something to do with disparity in resources, if there is one. If
Right.
The state has more people available to review the material. I mean, and keeping in mind that they also have other cases that they're working on. All the other cases don't stop just because this one is is moving forward. But I really think if you're looking for time, to explore, possible defenses and any other, avenues to attack the evidence, this would be, the types of arguments that you would probably make. I wasn't surprised when I heard it.
Right. No, I'm not surprised at all, but again, I just think I don't think it's as bad as she's making it seem. I think when it's all put together, it's going to go rather smoothly, in my opinion.
And we have 51 terabytes, not just one. So that's a lot. There's specialized knowledge. There's a lot to go through in this case. We also have another player in the case, and that's the presence of the media. This is a case that has drawn a ton of attention from the media, and it continues to do so, and I don't think that's stopping anytime soon. The impact of that is that we have found that when we want to talk to witnesses, sometimes they don't want anything to do with us. Sometimes they're people that have already talked to the media too much, and so we shouldn't talk to them or bring them into the case. So that's just a complication. We're working through it. We're working around it. But that's something that the court has to be aware of. I want to let the court know that there are over 400 potential witnesses in the innocence phase alone.
I'm going to handle this, Terry Martin. Terry Martin, no, that's not true. The 3D video exists no matter what. Has nothing to do with the fact that the home was torn down. I did a whole video on technology today. That 3D video existed no matter what. They got additional 3D video toward the end because they had an empty house and they wanted to get exact dimensions. But that's not the bearing we're talking about here. So your point is taken, but it's not true.
I personally and my team have talked to less than 10%, well, less than 10% of those witnesses. In the mitigation phase, our mitigation expert has been actively working the case. We've all been working alongside our mitigation expert. There are still well over 100 people left to try to contact and try to interview. And let me back up and explain what we do with mitigation. We are to learn Bryan's life story. We are to go all the way back to before he was born and learn his life story. We have to be prepared to talk about that in different ways. But it's not just about his life story. We're required to go 3 generations back on each side, mom and dad. The court can imagine that there are a lot of documents that must be collected and examined and reviewed so that we are aware of things that we would need to present to our jury if we ever got to that phase. We have had a lot of trouble collecting documents. Sometimes it takes a court order to get documents. Sometimes documents are missing. Sometimes they're very old and you have to piece things together. We're working through it, but I want the court to know it takes some time for that as well. There are records yet to be obtained that we need in both sides. There are still experts yet to be hired that we need to find an expert that has the right expertise and will work on the case with us. We do have several, we're working with them, but there are still more that need to be found.
Hey, Matt, question for you. So do you remember in the beginning of this case when the governor came forward and said he's allocating $1 million to the case?
Right.
Now, my question is, now I'm going on, I'm going to be on the defense right now. So if he allocated $1 million toward the investigation of this case, is part of those monies going to be delegated to the defense for their portion of the case? That would be only fair, would it not?
Yeah, I mean, I believe so because, you know, the budget, you know, allocation I would think is coming from the same pot possibly, but I just don't know, you know, how much that would be allocated to the public defender department and, you know, how much would be allocated to, you know, to the prosecution. But, you know, public defender funding comes from the state.
Right. I was just curious. That thought came to mind. I mean, they could certainly say that they went through that $1 million real quick before he was even apprehended. So, but
wouldn't have taken long, I'm guessing.
Yeah, it wouldn't have taken long.
And then let's come back to the discovery. I want to talk about some of the difficulties with discovery, and I want everybody to know that I am not disparaging the state when I say this.
Oh, she's backstroking again because what she did before, because she accused the state of doing what? Withholding evidence, holding back on discovery. And she got spanked for that. I don't care what anybody says, y'all. I guarantee you she was admonished and she got spanked by the judge for putting that out there. And also, you know, putting out there that the sheath was placed on the bed, you know, things like that. Now she's making sure that she's not going to fall down that hole again.
I'm describing a complication, a challenge, probably one that the state shares. In this case, we began asking for supplemental discovery in February of 2023. We had some initial discovery, and then we started looking at it and asking for other discovery. We are up to our 11th request for discovery, and there's, I think, 250 items total with subparts to that. The state will respond to us. They're not ignoring us. I'm not saying that at all. There's just a lot out there. But this is complicated because the discovery that we receive, the materials, there's videos, there's interviews, there's police reports, there's photographs, 13,000 photographs that come in, and they are not indexed. So you get a discovery file and there's tons of sub-files, and I believe this is the way the state's getting it too. And I believe this is complicated because we have multiple law enforcement entities that have been working on the case, and I believe they filter discovery through one of the entities and then it gets to the prosecutor. And I think they're hurrying as fast as they can to get the discovery to us. So I think they're giving it to us as they get it. But there's no indexing in it. So you must open each of those files and see what you have. And you might have police reports in sequence, and then you might not. And you might have photographs, but you don't know which officer took them. You can tell where they are, but you don't know which officer, and you don't know what day because the officers were in that residence multiple times. So that's complicated to try to match all of those things up. There are things that we've asked for that have taken, it's just taken a long time. The court knows we've had motions to compel, and we've had some pretty lively debates about what certain things that we should have and certain things that they don't want us to have for other reasons. Those things take time as well. We don't have complete discovery. I don't think the state has complete discovery, but we definitely don't have complete discovery. I'll give you a couple of examples. There is a video that's a really important video, and we early on received some of it, and we are still waiting for the complete of it. The court would know from our 11th discovery request that there's still outstanding portions of that video that we need to have, and I think the state's working through it, trying to match up video and sound together for the completion, the full several days worth of video. But there's not even an estimated day when we'll get that. And that is critical for us to review and hear all of that. So that's an example, Your Honor, that is not us saying we just don't want to go to trial, we just want to drag our feet. That is us saying there are critical things that we don't have. I am very concerned about expert reports. We have a draft of one, the cast report. The court had ordered that we receive the cast report. It's a draft. I don't think the state has it. I don't think they're sitting back on it, but I don't have that yet.
I don't think the state has it. I don't think the state's sitting back on it. Sound familiar?
Yes.
Backstroking. Patronizing
Hey.
this judge because she knows she better not go there.
And there are completed materials all over the place like that we just don't have. Our team speaks with the prosecution team fairly regularly about these issues. We communicate by text and by email about things like this that are coming up. We've sat down and spoken with them. They're very open to talking to us, but this just isn't a closed deal. There has to be a deadline on discovery. There has to be a target date where that ends. And then there has to be time to make sure that we've read every piece of it, watched all the videos, looked at all of the photographs, and know where they came from. A few months from now is not a sufficient amount of time to do that. There is no possible way I can even read or watch everything I have now or react to things that are still coming in if we're to have a deadline in time for a summer of 2024 trial. There is no possible way that I would be effective in my investigation, in my presentation to a jury, if I don't have the state's expert materials ready to give to my experts and then get them a report to respond to. There is no way that I am effective assistance counsel if I haven't looked at every bit of discovery that's available. Recently, Your Honor, as recently as January 4th, we received discovery that contained over 9,000 tips that law enforcement had obtained. And we've had, this isn't a new issue, I think the court's heard about this before. We've had bits and pieces of tips, and they've come in and we've reviewed them, but the 9,000 new ones we received January 4th, those were closed out in October of 2023. And I don't think the state sat on them. I think that's an example of the process that they close them out so they can give them to us, but they go through other agencies before they get in the prosecutor's hands to give to us. I have to read every one of those.
Matt, at what point does it become a little overzealous to claim that you need to investigate each and every one of those 9,000 tips that have already been looked at? I know that she's got to do it, but at what point does it become BS, in my opinion? You know, what do you think?
Probably when the judge makes a new scheduling order and says this is when discovery will be completed.
Yeah, right. Yeah. Well, when she gets what she wants, basically, right?
And I think at some point there will be a new scheduling order that'll give you, pretrial motions deadlines and discovery deadlines, and that
right.
that'll be the point.
And he says that. He says, basically, what can I do to help? Can I shorten these deadlines? Can I,
Yes.
tighten up on them? And he's going to do that. I thought he already did, but I think he's going to become a little more stringent. And because if you listen to her, she's looking at 27. Closer to 2027 before she'd be ready to go. It's crazy.
Yeah. Well, I think in a case like this that is as big as it is, being a capital case, pretrial scheduling orders probably get amended, several times just based on, things that happen in the case. And I don't think it would be unusual for that to happen here.
Yeah, no, it wouldn't be.
Hey, John.
Tips.
Yeah.
I have a two-pronged question that I just have to ask.
Okay.
Is it okay?
Yeah.
If you have recorded data of channels before they had somebody on or before they made videos about somebody and their viewership like tripled and you're basically the star of that viewership, would that person be entitled to any of those profits?
Are you asking for me?
I know, for me, because I have recorded data on several people who they drastically beat this like a dead horse, and their viewership, I have from what their views were to what they are now, and who's the star of the show.
Right. I don't know if Matt can answer that or not, but
Also, is naming 15 people by name a living, breathing person and accusing them of murder, drug dealing, rape, and various other horrific crimes? So is that like heavy duty serious? One person doing that. Recorded.
Matt, talk about libel, slander.
The first,
stuff.
yeah, the first prong of the question, I'm not, maybe if it could be rephrased, I'm not sure that I.
Well, what I'm asking is, should these YouTube creators cut these people in for, making a bunch of money off of them?
Ooh,
that's probably something, Matt. I mean, that's like a civil freaking, you're talking about a forensic,
Yes.
delve into their finances and stuff. I'm sure if somebody had the time and energy to do that, yeah, it could be done.
It's a
I've written it down, dang it, I got it.
kind of a loaded question. A lot of moving parts. As to the second piece of it, I mean, it kind of goes back to what I was saying earlier about, about defamation, slander and libel. You're always, you're in dangerous territory when you go on the air and you state something as as fact, but and not qualify it by by saying that something is an opinion, but just beyond that,
for entertainment purposes only.
Well, that in itself isn't a defense, though, is it, Matt?
No.
If they say, "Oh, this is just an opinion or or speculating," no. If you continually do it, I think you've eroded that defense.
Yeah, when the statement is continually published, and that was the term I was trying to think of earlier, was on the tip of my tongue. But when a defamatory statement is published, and it goes out to to third parties, that's when you that's when you have a problem. But there's just also the besides the the civil liability aspect of it, it's just not something that you should
If it's on a YouTube page and it's continually on there, then it's published every day. If somebody's watching it,
right,
drastic difference in views,
right?
and they do it up to 3 videos a day.
Let's keep moving. I've only got him for a little bit here. I see where you're going.
Call me Moscow.
There are things that matter to us in our innocence phase that have come up and been done, and I have to read them and appreciate them and react to them and see what's there. That's the duty I owe to Bryan. That's his right for effective assistance of counsel, to have me do those things. Your Honor, summer of 2024, it's impossible for us to do it. Our team constantly meets, we constantly work. We are on this. This is our priority. Bryan's our priority, but we are not going to be ready in June 2024. Your Honor, I want to also talk about some of the other deadlines. One of the things in the state's motion for scheduling order had to do with the alibi defense. And as the court remembers, we had made some submissions and we needed more information before we could do anything more complete. We're still in that circumstance. But when the court vacated its scheduling order last fall, that was part of the scheduling order that was vacated. So the state asserts in its scheduling order that our time has expired, and that just can't be, because the court didn't carve that out and say, I'm going to vacate everything but this. So we'll need a new date, but I'd ask the court to be really mindful of the other information we need. We need the cast report. We need other information of things that past agents and other specialists with the FBI might have done with cell towers and records. And I don't have all of those yet. I have some. And the state has pointed me to places that they believe I have more that maybe I missed in the discovery, and I'll look at those. But I'm going to need some time to do that. I wanted to let the court know as well, because the court's going to be considering a scheduling deadline for 12B motions. I want us to have a clear picture before we have that deadline. And the clear picture that I'm concerned about is the state's pathway of how Bryan Kohberger comes to their attention and is identified. I've read that PC affidavit over and over and over again, and I'm not sure. Over a year into this case and everything I've read, and I've spoken with our team, we're not sure how the state decides on Bryan Kohberger. I know different pieces, but I don't know where they fit together. And the more work I do, the less I know about how they fit together. And that is critical for us to assess 12B motions. So while the court's doing deadlines for discovery, I need the court to have something with the 12B keyed on when I have full discovery. I also think it would be appropriate for the court to allow windows to file additional motions based on later disclosed materials too. I think we'll just keep getting materials until the court sets a deadline for it to be cut off. Not anybody's fault, just the magnitude of the case. And so I think that would be something appropriate for the court to set as well. I think that covers it.
Thank you. One more question. So
sure.
I understand this. I mean, aware amount of disclosures already. But do we need a whole nother year after this summer? I mean, can I help everybody by having tighter deadlines to make things happen faster so that we can get this trial sooner?
That's a tough question. If the state says you have everything, and I believe they could say I have everything they have, but I know there's other things out there. I know it based on responses to discovery. If I had absolutely everything, all their experts' reports, I would still need a period of time to read and understand that. There's not a shortcut for the amount of time that it takes to go through everything. There's just not a shortcut for that. Having a deadline for discovery helps me. It just does. Having a deadline for expert disclosures, that absolutely helps me as well. I have the concerns of discovery that's not yet made available. I have the concerns of the time it takes to review all of the materials. And I have the concerns about the limitations we're finding with people being willing to talk to us, both for the innocence phase and the mitigation.
You know, she keeps putting it out there that this discovery has not been made available, while at the same time patronizing the judge, saying that she doesn't want to allude to the fact that the state's withholding discovery, when she just did it again. The facts are, people, that discovery the state doesn't even have. Okay, the state's waiting on it from the investigating entities, the labs, the agencies that are involved. So when they get it, they'll review it and they'll TOT it over to the state to the defense. Am I correct, Matt?
Sorry. Yes, you are correct. I mean, and like I mentioned earlier, you know, January 9th, there was an 11th supplemental discovery request. So I think that tells me that's what's happening, is that the state is sending discovery over to the defense, and then based on what is disclosed, you know, the defense is asking, you know, follow-up questions based on what they receive. So that results in supplemental you know, discovery request. So
exactly.
Discovery, from my experience, John, 15 years practicing, it's one of the things that people hate most about any case. And judges don't like discovery disputes. They don't like getting involved in the middle of them. I mean, they will when they have to, but it's just, you know,
it's really out of their control. That's why, because they can't really control the investigation. Everything's incumbent upon us to provide to the state. And if we're dragging our feet, then, I mean, there's reasons,
right?
You know,
and in a criminal case, you know, you think of like, okay, well, what could the sanctions be for failure to comply with discovery? Well, you risk not being able to call a certain witness or have certain evidence introduced. And so that's one of the things that, you know, judges have to be really, really careful about in this case, making sure that, you know, discovery is complete. And that's why I think, you know, you'll see at least a few more probably amended pretrial orders.
Sully Biker says, this for me is her being very cheeky, deliberately stoking the IGG conspiracy and mentioning the PCA. I think this is earlier, but I posted it. She's right. That's a very accurate statement, in my opinion. She is being very cheeky, but that's what she's supposed to do. You know, don't hate the player, hate the game.
Can I ask a question about FOIA requests?
Go ahead.
Okay. Is there any precedent to people using FOIA requests that, you know, has abuse?
Yes, in fact, you sign a form that states that you will not do that.
And you won't stalk a town or two.
Yeah, you sign a form.
So what do you do? How do you go about that? If it's, is there any type of?
Have you ever handled anything like that? Would you even know where to go with something like that?
I guess I won't be able to send out the 57 FOIA requests that I was going to have go out tomorrow. It's going to put a stop to those.
She's referring to abusive creators that are using FOIA requests to dox people, is what she's referring to.
I mean, other than just, you know, continual, you know, if the request just simply, you know, if it's material that's not discoverable, then they're just not going to ever, you know, they're not ever going to get the material, you know. But in terms of abuse of the process, I mean, the discovery in my cases, you know, happens through the, you know, normal discovery channels, you know, depositions.
Right. But see, when you show thousands, is that abuse?
Well,
it's not for a criminal or civil proceedings, I would say yes, but that I'm not a lawyer, and I'm sure he's probably never handled anything like that. But
Right. I'm
that's
sorry to ask a
that
silly
lies
question.
in the paperwork that this creator. So in a nutshell, this creator. I don't want to spend much time on this. This creator doxed a lady that was filing some noise complaints. She doxed this lady after she got the FOIA request, and even said where she worked, what she drove, pulled up her some report where she was in an accident where a guy on a bike pulled out in front of her, and the guy lost his life, and then she implied that she was drunk, and she wasn't. I mean, it was him that was drunk, but she said somebody was drunk, and just stuff like that. We can't go there right now, though. I got to have him focused on this. But,
Right.
all
So
right.
curious.
Phase, should we ever get there. I have significant concerns. We're working on it. If you could say everything's going to go according to plan, I'm going to give you these deadlines, and all of the materials will be in the state's hands so they can give them to you, and the records you need will be given to you when you ask, and the witnesses that you need to speak with won't slam the door in your face. If you could tell me that, then I would say I could be ready by March of 2025. And that's me saying I'm going to spend every possible hour on Mr. Koberger's case, which I've been doing and which I'm willing to continue to do, and so is the rest of his team. But my problem is that's best case scenario if we don't run into problems and delays getting records or getting people to talk to us. And if the next calls I make on the experts that I don't have yet secured, if they say yes and they're ready to go and have time to take it on, that's best case scenario. I'm nervous telling you I'll be ready by summer of 2025. I'm nervous telling you that.
This is priority for everybody, and I want to be realistic about it. I don't want to set it more than once. I only want to have one trial, one time, so it doesn't come back. We can only predict the future so much. I only have so much power, so I'm relying on counsel deeply. So let's go to Mr. Thompson and see what you have to say about all this. Just getting things ready for trial.
Ms. Taylor is not understating the amount of work that's involved in this case, Judge. I think that's fair to say, and there's more information that continues to be developed. It's kind of like you ask one question, you get an answer, and that leads you to another question. I know that Ms. Taylor and her co-counsel and investigators are encountering that. We are trying to provide things as quickly as we can, and she's right. There are delays in with the multiple agencies getting everything together. The tips, for example, were part of a nationwide tip line that needed to be completely shut down before we could get all the tips that were in it. And so that's why it took so long with these 9,000. I didn't count them, but there are thousands and thousands of tips, most of which are out there. But you're right, all of which need to be looked at to see if they have any potential relevance to the case. As I indicated to the court, if we cannot have a trial this summer, then I would say the earliest would be the summer of next year, for the reasons that I've described to the court about the practicalities of carrying on a trial of that duration with the high school, with the universities. We need to be realistic about being sure that we can get our witnesses here. We'll have something to put them. And there won't be undue interruptions in the community that could cause issues with the community's perception of the trial proceedings. I'm not quite sure what else I can offer.
You're making some kind of argument that changing venue, but I know we're not arguing about that.
And I don't think that's going to change anything, Judge. When this case has national, if not international, attention. This spring, I was at Association of Council of Counties board meeting in McCall, and there was more news every morning from Boise on this case than we see up here. Every doggone morning. I have people, friends in this community who have traveled to Mexico, and they say, people here were from Moscow, and immediately they want to talk about this case. It's not Moscow. It's not Latah County. It's everywhere. So I don't think that a change of venue is going to solve any of these problems. And the state's position on venue is that the case should be held here. It's a Latah County case. We believe that we can select an appropriate panel of jurors from Latah County. We have the tools to work with that we've discussed with Your Honor. In fact, we already have a fairly comprehensive draft juror questionnaire to send out so that the court and counsel can assess the level of knowledge and the feelings of the potential jury pool. But we think that we at least owe Latah County, the people of Latah County, the attempt to seat a jury here first, and not just rely on, there's been a lot of publicity. There's been a lot of publicity everywhere. The only place I've heard that there wasn't publicity is in Lewis County. Somebody was talking to a court down there, and they happened to mention co-location. Said, "What are you talking about?" So if we want to change venue, I guess we could go to Nez Perce.
Kind of small.
It's kind of small. Lodgings aren't very good as far as a lot of lodging, but I think that is a practical observation on this case. It's not just here. It's not just Moscow. It's not just Latah County.
Thank you, Mr. Thompson. So you're saying, looking at this realistically and the amount of information, evidence, non-evidence, that might be looking at summer of 2025?
I'm saying that could be where we end up, Judge. I am still concerned about the victims and their families. I mean, they have suffered for well over a year now with a lot of uncertainty, and that's painful. It's an everyday reminder, and they need some certainty and they need some closure in a timely fashion. But we know we also have to make sure, as Your Honor just said a few minutes ago, that we only do this case once. That it doesn't come back on appeal, that it doesn't come back for subsequent things saying that somebody made a mistake. We want to do it right. And the factors are in front of Your Honor. I think that you're certainly in a good position to make the best decision.
It's a decision that pulls me in two different.
I appreciate that, Judge.
Yeah.
All right. We don't need to go any further. He basically says, hey, I'm going to reserve the right. I'll need some time to think about this, blah, blah, blah. That's the end
Does
of it.
Matt know about the Crumley case?
I don't know.
The Oxford shooting?
I do. Yeah.
You do? Is
I
that
do.
government overreach?
Oh gosh. Are you? Do you mean in terms of charging the parents, or?
Yeah, exactly. And the way she put it together, and the way she presented it 10 times before they were even arrested. I got more.
Well,
we're gonna have Matt back. We're gonna have Matt back. I need to get him to bed because he's got 5 hearings that he's got to prepare for, and he's got 3 tomorrow. So I don't want to outweigh. I don't want to use them all up in one night, Matt.
No.
Stacey, I appreciate you and I love you to death, but we can't. I can't ask Matt to dive into something. But what I want to do is dive into this right now, Matt. And
Sure.
Grizzly Bears makes a comment down here, and I want to talk about that real quick, and then we can wrap it up. Is the PCA written in a way that you can see how they become focused on Bryan, or is it poorly written PCA? With your experience, what do I think? I think that PCA, I was always taught less is more on a PCA. Get away with what you can get away with. If they send an information, which is when a judge or the state attorney asks for additional information, send it to them. If they don't, and they don't null pros the case, they have to send you an information before they null pros it. So if they don't null pros the case and you roll with it, and they set it for a trial date and hearings and move forward with it, then you're good, because all the rest of your investigative stuff is still under your hat and you haven't given it to the defense yet. So do I think that this PCA was well written? Yes and no. I think it was an overzealously written PCA, in my opinion. I would have put about maybe 45% of what he put in that PCA, because a PCA is a probable cause affidavit, and all that other stuff really didn't need to be in there, in my opinion. Matt, I don't know how you feel about it, but that's how I feel about it. It's obviously written by an experienced kind of a detective that wants to make sure he dots all of his I's and crosses his T's, but I think some of what he put in there might hurt him.
Could be that the PCA in this case was kind of a team effort, that was written by,
Right.
that had
That's for sure. Yeah.
Yeah, more than one author, including potentially, someone from the attorney general, attorney general's office, something like that. But it's but because of they included a lot of information, but then because of the gag order, you have so much speculation on what does this or that mean, in the PCAA, like we were talking about with the frozen shock phase
Right.
statement. So it's a lot of it's a lot of guessing, but maybe when you have a department that probably has never been faced with crimes like this before, they certainly wanted to make sure that they were going to have enough for an arrest warrant. I definitely took that away from it.
Right. Absolutely. Well, at that point though, I mean, it's still a PCA, but it was just they needed enough to extradite him from Pennsylvania, and then they had their hearing. I don't know. I've never encountered something like that. I don't know if I would have done it any differently. That's something that I never really encountered, was an extradition order. I was part of one, but it wasn't my case. So I don't know. Could they have handled it any differently in that case? Could it have been less is more just to get the extradition? Or did it matter? Does that make sense? I don't know. That part's always kind of concerned me. I think it was just way too much in that PCA.
Mm-hmm.
That's just me, but yeah, absolutely, a lot of eyes and hands were on that for sure. But I think there was too much in it, and it opened up Pandora's box to a lot of questions because of the gag order, because we don't have anything to go along with that PCA, which was the investigative techniques that were used that are documented in the incident and supplemental reports. We have none of that. All we've got now is a PCA with this, and this, and that opened up Pandora's box, and for nothing but speculation and innuendo and lies and these irresponsible, crazy theories, constructed by these irresponsible, money-hungry, pathetic, disgusting creators, in my opinion, who have no conscience.
Oh,
that's
also,
another show.
And scrutiny of the law enforcement officers on cross-examination too at trial.
Oh yeah.
Based on the statements.
The frozen shock phase statement.
And the investigation in general is that
right.
When you're over, when you include potentially more than what may have been necessary, to get the warrant that you were looking for, that you just have to understand that you're opening the officers up to more scrutiny on cross when you get to trial.
Exactly. And they have all this time to think and ponder about it now without any of the investigative, elements or techniques or anything that has led them to what was in that PCA. So it's just created. And I would hope, I don't know how you feel about it, but I would hope that moving forward, I mean, we have a process when it comes to jury selection. We have questionnaires. We have, just because someone says that they heard about this case doesn't mean that they wouldn't be selected for a jury. They just have to not be biased. And that's a process, and it can get very intense. I think the jury selection in this case is going to be epic in itself. So, I mean, I don't know how you feel about that, but I'm sure it's going to be a fight. First of all, it's a DP case, and in a DP case, you can't be against the death penalty. So, and who's to say somebody doesn't infiltrate the jury pool and is against it and lies? How do you vet those people? I mean, that's hard.
Right.
I mean, I know you've been a part of jury selections, but
Yes.
I know it's hard.
Well, and you have to understand how many strikes you have, for potential jurors, and use those accordingly, and make sure that you don't inadvertently strike a juror that you may want in the jury pool.
Right, exactly. And it has to be, go over that a little bit with everybody so they understand. You have 12 jurors. So the defense gets a shot at them and the prosecution gets a shot at them. So just go through just real quick how that works in a Cliff Note version, so that people will understand how hard this one's going to be.
Yeah, well, you have the voir dire process, which is a jury selection, and you have jury questionnaires that go out to the potential jury pool, and the idea is that you want a good cross section of the community. You don't want a jury of the same demographic, essentially, because the idea is that doesn't result in necessarily a fair process for the defendant. So voir dire is a process where the defense and the prosecution each get to ask the prospective jurors questions, and the questions are typically about have things like, have you ever been arrested? How do you feel about law enforcement? Certainly they would be asked questions about the death penalty. Questions like, would you be able to, put any prejudice or bias aside and listen to the facts, and judge the facts, because you're trying to prevent someone who's trying to get on the jury for some self-serving reason. Right. You want jurors that are going to listen to the facts and judge the facts accordingly, according to their weight, right? So that's kind of a nutshell version of what voir dire is. And each side gets a certain number of strikes, meaning that you can simply strike a juror for any reason, but then there are strikes for cause, so that there may be something in their answer, or they may know one of the law enforcement officers. That's one that I see sometimes,
or they may be former law enforcement, or may have a family member that's former law enforcement, period. That could
exactly. I mean, depending on their relationship to someone involved with law enforcement, or even in the current investigation, it would be appropriate to strike them from the jury.
Here's something that I came up with, and tell me what you think. You would know better than I, but it's surrounding the house being torn down. So a lot of argument out there is, well, what if I'm a juror and I wanted to go to the house? So herein lies on the questionnaire. So do you think that the judge would mandate that they have in the questionnaire, hey, look, we no longer have a crime scene. We have 3D imaging. We have all video. We have detailed this crime scene from top to bottom, every square inch. You are not going to be afforded the opportunity to travel to this crime scene because it is no longer there. It has been torn down. do you have a problem with that? Now, if I were in charge of this case, if I were the judge, I would mandate that be part of the questionnaire. Do you think that would be smart?
I think that, given the amount of publicity and, kind of difference of opinion about whether the house should remain or be demolished, that it wouldn't be a bad idea for actually the state and the defense to jointly go to the judge, when it gets time to create the jury questionnaires,
Right.
it's a
Because
different.
they both conceded to tear it down. They both agreed to tear it down.
Exactly.
So-
They stipulated. And another instance where the parties jointly went to the judge was and of course it was a different judge at that point, but in the very beginning of the case, when the conflict of interest came up with Ann Taylor related to Xana's mom.
Oh yeah, she represented her mom. Yeah,
they jointly went to the judge and dealt with that issue, which I think was the prudent thing to do.
Right. It was a prudent thing to do. Absolutely. So yeah, and then basically what I was trying to explain to my audience was that if it came up, if either side brought that up as okay, well, we no longer have the house to go to, then it would be grounds for a mistrial. So, and they would be severely admonished by the judge for doing that. And so if both sides stipulate and concede to the fact that they agree that the house should be torn down, then any juror that has any expectations of visiting a crime scene should know that the crime scene is no longer there. And technology in the CSI age that we live in today will provide you with a much better view than actually being there, believe it or not. So yeah, I thought that was, I'm not patting myself on the back, but I thought that was a pretty good idea.
No, and I wonder, it is. And I wonder if the judge would say, in the condition, the house would not meet literally the legal requirements for
it was a shell. Yeah,
for a jury visit and say, we're not going to even deal with it, on the jury questionnaire. It's not even a question that potential jurors could be asked because it didn't meet the legal requirements. So I don't know. It's an interesting.
But that was the whole debate and YouTube world was.
I want to ask a question.
Oh well, we don't have a house, so they can't visit a crime scene. So I wanted to put that to bed, and I think the best way to put it to bed would be to actually have that part of the questionnaire. Go ahead, Rachel.
Wouldn't it be an issue of jury safety not to go to the house because anybody with a long range camera could take a picture of these jurors, and these online sleuths are so crazy they'll dox jurors.
Oh, they fly a drone right over them.
I mean, wouldn't that be an issue for mistrial too? I mean, if that was to happen.
There was an instance in the Rittenhouse case, Kyle Rittenhouse, where someone actually got in their vehicle and followed the jury van, at the end of a day of trial, and the person was pulled over by the cops. The jurors were being taken, to their hotel, and
that'd be a U.S. Marshal, probably. Actually,
I would think so. And they attempted to blame their producer, on.
Oh yeah, I remember hearing that. That's right.
And so, Rachel, I think you raise a very legitimate question there. We're always concerned about doxing. I mean, even with trials being live streamed, there have been instances where the camera has accidentally caught, a picture, a juror, and it's not intentional, but it's something
just
that
coming and going.
Yeah, and it can happen, and the court's going to be very concerned about. But I just think that the parties stipulated to the house being demolished, and
and that's what I said. I said it's over. It's a moot point. Get off of it, people. It really is. It's who cares, And then I did a show showing the 3D imaging and the way that crime scenes are processed today. And it worked, and it did help a lot of people understand, but still, you just had those people that just, they don't get it.
Can't fix stupid.
You can't. And you know, the house was nothing but a shell. There's no furniture in it. You know, people, if you've never never looked at a house to buy that was vacant, it doesn't sound the same as it'll never sound like that again until it's vacant again. When you put furnishings in it, you're not gonna get the same effect. Lighting's gonna be different. Everything in that house was. Now we can debate all day long whether they should have even done that in the first place. But you know, I'm with technology today. You know, I am old school, but I've seen technology and I think it's amazing. They're going to be wearing these Oculuses, and you know, what better way to, if you have a juror that's concerned about a certain area of the house, that juror can sit there and when they're deliberating and they're looking at evidence, and one juror may be concerned about another portion of the house that nobody else is concerned about, but they can go directly to that part of the house and look at it. And I think that's awesome.
It's not possible to recreate the conditions, you know, as they would have existed, you know, in the middle of the night, when,
right,
you know, when the crimes took place. And I think that's the key. I mean, there was a case in Mississippi where a teenage girl was, you know, set on fire in her car, and you know, they took the jury out to the scene, but it was easier to, you know, you had essentially the conditions, you know, obviously there was not a car there for them to see, but that's far different than what you would be trying to do by taking this jury, you know, to what, as you said, John, a shell, you know, where you can't even come close to recreating the conditions.
And you couldn't come close to concealing their identity from people being able to take pictures of them and everything else. I mean, seems like juror safety was a concern for the defense and the prosecution and the judge. It's probably why they all signed off on it getting destroyed.
The Murdaugh trial.
Well, the Murdaugh case was different because it was in a rural area.
Yeah, they got the picture of the juror though.
Yeah, I agree. I mean, we live in a different world today. So Matt, I want to thank you, man. I know we went over about an hour and a half longer than I promised you. I apologize for that, man. Told you, just tell me. Him and I were texting back and forth. I was making sure he was all right, everybody. So he said we're good.
Yeah, there were just maybe like two quick things before I go.
Yeah,
that's what I wanted to mention. First, on the, you know, on the death penalty issue, you know, the statute provides a time frame for the state that they have to file a notice of intent to seek the death penalty. They can always amend the notice later. You know, they can also agree with the defense to extend the time for the notice, but the law requires them, whether they ultimately seek the death penalty or not, they have to file the notice.
Right.
The other thing is for, you know, venue transfer, you know, that's also governed by the Idaho rules of criminal procedure, and there's a difference when, you know, the case is going to be transferred to a different county within the same judicial district, or if it's going to be transferred outside to an outside district. So, you know, that's in the rules as well. And I mean, everything that was discussed, you know, in the hearing can be found, you know, in the statutes and in the rules of criminal procedure. And, you know, I mean, I've been looking at those things for a year now as the case has been going. But
right, yeah,
those are the only two other things I had, I think, John.
So what's your
Matt,
prediction?
Black Austin would like to know if Jennifer Coffendorfer is an expert in your opinion.
I mean, I don't listen to her enough, I suppose. I mean, it's hard.
Yeah, you reserve the right to remain neutral on that one. Trust me. Don't worry.
He also wants the ladies of the chat to know he's always accepting applications. He's not a single guy, but He's
Yeah.
accepting applications, ladies of all
We got
types.
plenty of comedians in here, Matt. So listen, I'm not to put you on the spot, but prediction as far as when this trial is going to start. What do you think?
I think it's going to start sometime between May and August of 2025.
So you think this year's out?
I think this year is out, and the reason I think that, John, is because when the judge heard Bill Thompson say that we could end up there, Judge.
Right.
I think it was a realization that both sides don't believe that the case could go to trial this year. But I do think that the judge is gonna hold
hold them to the fire.
status conferences and discovery conferences and try to keep them going so that we don't get out to like 2026.
Right. And everybody out there, it's not that unusual. I mean, serial killer cases take years and years and years. This isn't a serial killer; it's a mass murder. But we don't know. What about? Go ahead.
We can never count out the possibility of a plea. Do I think the state will offer a plea? No. I think if they did, if I were going to offer a plea or even engage in discussions, I would demand a full allocution, meaning that
Bill Thompson's exact words were no plea, no matter what, never.
That's because he knows he has a strong case.
He says that. I think in reality, DA's offices, under certain circumstances, always are willing to consider. Because the families could come to them and say, "Look, this has lasted long enough," and if he fully allocutes, meaning he explains what happened, that's probably the only way that if I were the state, I would consider a plea. And I'm guessing in return, obviously, death penalty off of the table. But
I never thought about the allocute part. I always, and I'm glad you brought it up because I never thought about that part. Because my contention was he has nothing to offer. There's no corpus delicti missing. Nothing's missing. There's no body of the crime that he's buried somewhere that we can. Okay, Bryan, right. Tell us where the body is, and we'll take the DP off the table.
Right.
So that was always my contention. But now that you said that, but then you're getting into, do we really want to know what motive is? Because in allocution, you basically you want to find out what the motive was, correct? That's what I would want to know. Why? Sure. We pretty much know how, who, what, when. We want to know why. So motive is not something that the state or anybody has to prove. It's method and opportunity. And, motive is a bonus. So, but I never thought of it like you said, maybe they would do that. I just don't see it because isn't he retiring? Thompson's retiring soon, is he not?
I heard that. Yeah.
So you're there. See, there's another problem. Although he's not going to. I don't see him doing much presenting. He's going to have somebody very eloquent telling the story. Mm-hmm. I don't know that he would be the guy for that job. You know what I mean? So
I have a question about the death penalty.
I think that guy sitting next to him would do a good job, though.
Absolutely.
That guy.
What are the extra parameters for death penalty?
What was that? I'm sorry.
And then they have to have a death penalty case to get the death penalty approved. Don't they have to have extra parameters of the case secure to get the death penalty?
Aggravating circumstances.
Yeah.
That's part of the statute for the DP.
Right.
That's all in that statute.
Does he know what that is? That's what I'm asking. What are those?
It has to be heinous, atrocious. How's it go? I forget how it goes, but they all pretty much read the same.
Definitely checks those off a lot.
Yeah. I forget. We'd have to look it up. We'll do that. But Matt, I'm gonna let you go, man. I really appreciate your time, and you're a good friend for coming on. And Matt's gonna come back, and Matt's always hitting me up. Hey, we should. I heard this, So anytime he wants to do that and come back on the show and address something, you can use me. I'm your buddy, and we're friends, and you can always have this platform to speak your mind, brother.
Brush up on FOIA request laws.
And
Thank you, Matt, so much.
And Rachel, on the aggravating factors as to the death penalty, if you look in the Idaho general statutes, it's 19-2515 goes into the the aggravating factors on a in a death penalty case. So probably start there.
Absolutely. We'll look that up. We'll post it on the show. And in fact, look it up, Rachel.
Does it matter how they identified BK as a suspect?
Well, it depends.
Were
I
you
would think.
talking about me? Because I didn't say anything about any of that.
We're always talking about you.
Oh, I don't know. Somebody.
No,
must
that
like
was biology
You
101.
just
Just want to know.
Oh, he thought he meant Stacy, not Rachel.
Oh, sorry
okay.
about that.
No, he's talking about her question. That was good.
Right. I mean,
I didn't have a question about it. He's got the wrong
Yes, you
mind.
did.
Yeah,
Don't
that
you
was.
ask the
that was
question?
you.
I didn't ask a question.
I mean, certainly when you arrest someone that where there's no probable cause, I mean, that's definitely definitely an issue. But the PCA doesn't even fully explain what the the law enforcement sources and methods were. When we hear all those officers testify at trial, we're going to get a full glimpse into their investigation and how the question of how did they get to him will finally be answered.
And Matt, just so they don't take what you just said out of context, the PCA doesn't have to go into that. That's what the incident supplementals and all that is for. The PCA only has to have the elements of the crime. So.
Yeah. I mean, we're going to get, we're going to know, at trial when there are going to be so many law enforcement witnesses because you had law enforcement in 2 different states and the FBI. So we're going to hear from plenty,
Anne's asking over and over again, though, how they got to BK. Is that too big of a deal, or is it just something her making noise?
She's sending subliminals out there.
It sounds like something I've heard on other shows before, and I wondered.
Right.
I heard her say that, and I thought, wow, I've heard that kind of thing before.
That was pretty insane for me to hear her actually say that. Now that she doesn't believe that, everyone. Ann Taylor does not believe that. Oh well, I still haven't seen anything that would lead me to believe. Yeah,
I mean, it's implying that they had. Yeah, I mean, it's implying that they had no reason to zero in on him as a suspect, and or they had no probable cause. That's what that sort of. I never would have made a statement like that. But
yeah, that was, to me, that was almost reckless for her to say that. But hey,
I didn't understand.
She might be getting admonished again.
Well,
I think she's just playing up to YouTube.
She's playing up to social media for sure because she knows that's her outlet to tainting a jury pool.
Yep.
And it's not going to happen.
Like a bunch of trained SEALs over here on YouTube.
All right, Matt. Well, I appreciate you, man. Anything else you want to say?
Just to thank you all for the great questions, and thank you for letting me come on, John. I appreciate it. I've heard a lot of
anytime, and good luck with your hearings.
Thank you.
Kick some butt and get some justice for people.
I'll do my best. Take care.
All right, buddy.
Thank you so much.
All right. Thanks.
All right. Bye-bye. Well, that was awesome. That
nice guy.
Matt's a great guy.
Yeah.
Very, very good guy. a wealth of knowledge. I can ask him about anything and he'll answer it. And
Oh,
you know
yeah.
what? He's not one-sided. You know, he'll tell you what he thinks.
Right.
He's very, very
Yeah, he's
versed.
even keel.
He
Yeah.
is. But that, folks, was a show.
I
That
think we did pretty good on that one.
is what all of you should want. Shouldn't want to go to these shows that make up this garbage every day and make up these lies and what if this and what if that and what if, you know, now what's the latest? Oh, now, you know, Bethany and Dylan are back to suspects number 1 and 2 or 3
Oh,
and
yeah.
4 or whatever
Back
now.
on the chopping block.
You know why? Because they don't have anything else to talk about. Because they're not creators. They're bullshitters.
Keep in mind, these young women are 21 years old.
Like they're going to
They
be
should
able
be
to. They're going to be
embarrassed.
able to. Like Rachel said it. I've said like these young ladies who basically, I don't know, but I'm going to guess that they didn't grow up in the hood, so they weren't exposed to a whole lot of crime. Most of what they've seen has maybe been in the movies, but I can guarantee you being put up against seasoned interview and interrogators, they're not going to stand there and lie about what they saw or didn't see because some
Well, to
frat
manage to keep their
told them
mouth
not to.
shut this long with what they've taken shows extremely solid integrity. They're going to come out of this like rock stars, is my bet.
Well, that, and for law enforcement, for the investigators all around to have not leaked things out on this case blows me away.
Yeah.
Do you know how much a photo could potentially be worth in this case?
Oh, I feel horrible
I
for them.
mean, it's
I can't imagine.
amazing to me, and it shows the integrity of all involved in this case for us to not still know anything.
Dylan, if you're listening, I got your back.
Yeah, Dylan, you're
got
going to
the
be
goods.
rich. You're going to be rich in the end, and I hate to say it because of this, but in the end of all this, you're going to make a lot of money because these people have really, really, really done a number on your character, and yeah.
Wrongly.
Well, Bethany too.
Yes, all of them. Jack
The
D, all of
families.
them.
The families.
Yes,
Period.
all of them. Yes. The Chapins, all of them.
The owner of the
Samantha
food truck.
Nelson as well.
I talked to the owner of the food truck. I actually just talked to him 2 weeks ago. He's definitely pretty pissed, and he's moving forward against these, at least one of these creators. He'll be paying
That
him
was
for the
serious.
rest. He'll be paying him for the next 2 decades because he'll get that judgment against that little weasel.
Drip Drop
I promise
even
you.
insinuated that Brent Kopaka's best friend had something to do with it.
Yeah.
And he even and that's not all. There was a new video by Nika's Neuro Nuggets. Was Dylan a tranny, and Dylan was the source of the other male DNA.
Mm-hmm. Justin.
Wow.
That shit crazy.
Mm-hmm. Yeah.
When does it stop, y'all? When does it stop? Each and every one of you that if you go to those shows, I'm going to say it and I don't care. If you go to those shows and you click like, shame on you.
I'm convinced these people know
Shame
each
on
other
you.
somehow.
Now, if you go to those shows and you just want to go for the Jerry Springer effect and just look at what idiots they are and try and scratch your head and figure out whether, you know, I can't believe these people actually exist.
How
Can't believe-
how do these people call the same places? How does that happen? All these people that have come out of the woodwork, they pick the same exact channel to call. But they've never been on YouTube before. They don't know anything about true crime, but they just know to call some obscure channel that just started like last year. Okay.
Oh, well. You know, karma.
Sounds like a network.
Karma's a bitch. Sounds like a cult.
Yes.
One of these creators goes, her whole contention when I called her out was, I don't have anything to do with those people. How could you put me in the same class? Now look. They're like inseparable now. They're on each other's show every day.
Yep. It's
put
a
'em all
ring.
in-
It's
put
a
'em-
circuit.
hey. Put them all in the same convertible and let them drive off a fucking cliff just like Thelma and Louise.
Bye.
True. You guys have a good night. You guys.
All right, thank
Bye.
you. Hey, Stacy, sorry about that. I was clicking on someone else and you were right below them and it was moving and I clicked you, so I'll take care of it tomorrow. That's why I wanted
I don't
you
know
to
what
come
you're
on
talking
YouTube.
about.
Okay.
Oh, the one, my thing about, I hope she hired her because it's going to be a fun train wreck to watch.
Yeah, no,
Yeah.
I
I hope
inadvertently
so.
blocked
That'd be
you.
great.
I inadvertently blocked you. That's why I
Oh,
said,
that's
come on
okay.
right now.
I'm blocked everywhere. It's all right. I don't take it too
Well, no, I
personally.
have to go back. I can't do it during a live show. I can't unblock you. I have to go into my settings and unblock you. But I
It's
did
all
have to
right.
block one person that thought they were being funny. I think. I don't know. I don't even know what they were saying, but it was disrespectful to women in general. So I blocked them.
Yeah.
All right. You got anything?
Nope.
Stacy,
Well, I have a
Rachel?
lot, but I don't have any way to put into words.
I saw where you were going. I just didn't want to, you know, I wanted to stay on topic, but I get you. You got the point across. We've got the point across, but we're not done with that. You know that.
Because it's excessive.
It's
daily.
excessive. It's excessive.
I don't know how they afford it.
And it's criminal.
I
So,
think so.
oh, it's definitely criminal.
Yeah.
One of them
Well-
thinks that they got away with something. Little Miss thinks she got away with something because I just let her talk. She didn't look. She kept saying there was no appeal. But when look again, why would you say there was no appeal? Why'd you keep saying that? Because you knew there was appeal. So I just let her run her mouth.
Because the more they say it, they believe it's true.
Oh yeah, I just let her run her mouth.
Just repeat, and they know it'll spread like a virus.
But I got it where it ain't never going to disappear. And
You
my
guys
buddy's
have a
got
good
it.
night.
My buddy's got it. He's got all the info, so we're good to go. All right. Good night, Stace.
Nighty
Rach,
night.
got anything?
How do I get out of here? Let's see.
I'll get you out. Bye.
I'm good. Bye.
Rach, you good?
Yeah.
All right.
That was a great guess, though.
Yep. It was a great show. I knew it would be a great show. I've been wanting to get him on here for a while, and he had a little time, so figure we'll get. Now, listen up, y'all. What we have coming for you guys, ladies and gentlemen, is awesome. Rachel, did you get off of here? So stay tuned. No one else has it. I have got a very special guest that's going to be coming on with another attorney, which is his son, that handled a major serial killer. And probably, in my opinion, one of the most prolific serial killers of all time. And he is the best interrogator I've ever seen in my life. So that's coming very soon, probably by this weekend coming up, if all works out. But in the meantime, I've got 12 shows lined up. And you're going to understand when I start to show them. You'll know exactly where we're going. And they'll give you the most unique perspective into these crimes, these types of crimes that you've ever encountered, because you're going to know exactly what a person did leading up to it. It's a little vague, I know, but you'll get it. Matt just texted me and said, thanks again for having me. He had fun, and we appreciate you, Matt. So look for Matt to be on the show a lot more. And those other people that I'm mentioning, I'll drop some names later on. But right now, we're putting it all together. You'll never hear anything like this again. Not from a YouTube creator. It's going to be really cool. So that being said, I want to cut y'all loose tonight. Hope you had a great weekend. And I hope you have a great Monday, Tuesday, Wednesday, Thursday, Friday, Saturday, until next Saturday and Sunday. And we'll probably do something before then. I'm just really busy with work. You know, I don't have the opportunity to sit at home and suck off a government tit and play on YouTube all day. I have a career and a business that I have to run. But I like you guys a lot. So that's why my shows are a little bit longer. But these next shows, again, are going to be awesome. You guys have a great night. Peace out.